and welcome to the fifth hearing of the U.S.-China Economic and Security Review Commission's 2023 annual report cycle. I want to thank everyone for joining us today. I also want to thank our witnesses for all their hard work and sharing their expertise in the preparation of their testimonies this morning. I also want to extend our appreciation to the Senate Environment and Public Works Committee for use of this hearing room today, as well as the Senate Recording Studio for their assistance in live streaming this event. Today's hearing will assess China's increasing use of the law to advance the CCP's goals, both domestically and internationally, and the implications of these efforts for U.S. interests. Since taking power, General Secretary Xi has overhauled China's court system to make it more responsive to central authorities, and has made strengthening the effectiveness and enforcement of laws a tenet of his governance reforms. But whereas courts and the rule of law remain the great levelers in our society, in China, the rule by law is simply a tool to ensure the institutions are aligned with the party's objectives and capable of implementing the party's political agenda. Recent trends have seen the deepening politicization of Chinese courts, with U.S. entities facing increasingly unfavorable and unfair rulings, often aimed to advance Chinese industrial policy objectives. Internationally, China is now seeking to export this legal model around the world, often using its growing influence to enhance global acceptance of these alternative legal models and institutions, frequently by coupling these authoritarian legal concepts with its investment initiatives around the globe. Chinese entities are also seeking more favorable outcomes in dispute settlement mechanisms, sometimes by forcing parties to accept contractual language that requires disputes to be settled in Chinese courts, subject to Chinese law, and subject to Chinese procedures abroad. Beyond increasing China's sway in commercial disputes, Chinese representatives in international organizations are also attempting to shape the rules and norms in emerging fields of international law, including space and cyber, often to advantage Chinese interests. And where China cannot influence the initial shaping of international law, it attempts to subvert the norms and laws that underpin it, often simply by repudiating and violating international treaty obligations. You're not simply content to circumvent international law. China couples these violations with crafted legal justifications to support their positions. A better understanding of these efforts is critical for the ability of the United States to appropriately respond. Throughout this hearing, we will examine how China is attempting to pair its growing political, military, and economic influence with these distinct legal strategies and the implication of these strategies for U.S. policymakers. More critically, we'll hear about Chinese efforts to enforce its laws beyond its borders, and how the extraterritorial application of the liberal law challenges U.S. interests, values, and our court system itself. We'll also consider how China uses its own system to influence proceedings in other jurisdictions, for instance, by preventing parallel litigation against Chinese parties through the use of anti-suit injunctions in order to seek more favorable rulings in IP-related cases. Finally, we will address how China interacts with the U.S. court system itself. China's legal system lacks many of the fundamental cornerstones that our legal system and other legal systems share, including that judicial outcomes be based on neutral decision-making. Moreover, key Chinese legal documents contain provisions that simply are not enforced. And yet at the same time, many directives that carry the weight of binding law are presented as non-binding policy guidance or may not even be publicized, including contained in some secret party documents. Because of these differences, U.S. courts often lack sufficient familiarity to fully assess the Chinese legal system or the Chinese judiciary, including whether those tribunals can be impartial, whether the tribunals provide sufficient procedural safeguards for litigants, and whether Chinese law affords those litigants with sufficient remedies. Likewise, U.S. judges often do not have sufficient familiarity with the politicized and illiberal nature of the legal system when considering whether to offer comity to Chinese courts or recognizing judgments previously rendered in China. As a nation founded upon the rule of law, the United States must do all that it can to uphold this principle both at home and abroad. And understanding how the CCP views law as an instrument of its authoritarian power is crucial to managing U.S.-China competition. I will now turn the floor over to my colleague and co-chair for this hearing, Commissioner Jacob Helberg.
Thank you all for joining us today. Thank you, Commissioner Goodwin, and thank you to our witnesses for sharing your expertise and the work you have put into your testimonies. 20 years ago this year, President Bush proclaimed in his State of the Union address that free people will set the course of history. Suppose a member of the House of Representatives had stood up that night, warning us that in 20 years' time, Chinese police stations would be found in the heart of New York City, Chinese spy balloons would fly over American neighborhoods, and Chinese surveillance spyware would track dissidents across our land on 150 million American cell phones. No one would have believed in such an outrageous erosion of our national sovereignty to a genocidal Leninist adversary. And yet, that is exactly where we find ourselves today, with wall-to-wall postmortems of how American strategy over the last 20 years has fundamentally misread the Chinese Communist Party. One has to wonder, where will we be in another 10 or 20 years' time? What will future postmortems record of today's policies? Will they look back on an America that remains still too slow, too reactive, and too incremental in the face of radical changes the likes of which the world hadn't seen in 100 years? General Secretary Xi forecasted as much on his last visit to Moscow. I myself hesitate to predict how history will judge the early 2020s, but the answer depends in no small measure on the policy choices and decisions we as a country make today. This hearing is about lawfare, and yet, 5 years ago, General Secretary Xi bluntly reminded us that laws are the luxury of sovereign nations, while tributary states are law takers, not makers. He declared, quote, "A new world order is now under construction that will surpass and supplant the Westphalian system," end quote. In other words, General Secretary Xi plainly stated his intent to upend the basic concept of equal and sovereign states that has defined international politics for 400 years, and he has made alarming strides on that promise. The rest of the world is left to ask if the Chinese Communist Party is brazen enough to attack the sovereignty of the world's largest economy. What hope of resistance and independence is there for any smaller country? We should be clear-eyed that China's assault on American sovereignty is not just a gray zone attack on America, it's an assault on the Westphalian system and on the sovereignty of nations everywhere. Against this backdrop, our witnesses today will examine how the CCP seeks to change, subvert, and influence the enforcement of laws beyond its shores and is seeking extraterritorial influence to advance its agenda. Today's hearing is particularly timely as Congress rightfully considers historic measures to bolster American national security. The first responsibility of this commission is to help inform that debate with actionable policy recommendations commensurate to the threats this country faces as they relate to the Chinese Communist Party. Thank you.
Thank you, Commissioner. Our first panel will examine Beijing's ambitions to use law as a method of promoting the CCP's political goals domestically as well as internationally. First, we're happy to welcome Dr. Moritz Rudolph, a research scholar in law and fellow at Yale Law School's Paul Tsai China Center, who will address the party's views on law and how it is exporting those legal concepts abroad. Dr. Rudolph has written extensively on legal developments in China under Xi Jinping. Next, we are also happy to welcome Vivian Bath, professor of Chinese and International Business Law and the associate director of the Center for Asian and Pacific Law at the University of Sydney, who will address China's approach to international law and how it is seeking to forward its legal influence and power in venues including commercial law. Ms. Bath has published significant research on dispute resolution and arbitration with regard to Chinese commercial pursuits. Finally, we'll hear from Attorney Dan Harris, who we're happy to welcome back to the Commission, partner at the law firm of Harris Bricken, who will address how China's cyber governance, including legal regulations on data practices and cybersecurity, have impacted international firms operating in China, particularly those in the tech space. Mr. Harris has decades of experience working with U.S. firms operating in China and around the globe. Thank you all very much for your testimony. I want to remind the witnesses to try to keep their remarks 7 minutes. Dr. Rudolph, we'll begin with you.
Thank you very much for inviting me to the hearing. In my testimony, I will focus on the CCP's promotion of the rule by law, prioritizing international dimension and implications for the international legal order. According to the CCP's approach and following Marxist thinking, Beijing views the law primarily as an instrument to achieve its material development goals. The Chinese leadership rejects the concepts of independent judiciary and checks and balances as erroneous Western thought. The CCP acts strategic, systemic, and long-term oriented. The law shall be utilized to achieve the so-called China dream of great rejuvenation of the Chinese nation by 2049. The CCP strives to build a Chinese version of the rule of law. Where it is consistent with the objectives of the CCP, Beijing draws on Western aspects of the rule of law, especially when it comes to regulating civil law matters, jurisdiction, and procedural matters. To promote Xi Jinping thought on the rule of law, the CCP prioritizes the following aspects: party control, efficient application of the law by the state, including strict law enforcement, modernization through the law by regulating and utilizing new tech, professionalization efforts, theoretical research, and educating the public. For many people in the PRC, those efforts could lead to more legal certainty and less to less arbitrariness. At the same time, the space for opposing the party state is shrinking. At the international level, the law serves as a tool to safeguard China's sovereignty, national security, and development interests. And the PRC has become more active and self-confident in the realm of international law. Beijing has become more effective in promoting its position within the UN system or getting preferred candidates elected to crucial UN positions. Also, it has been gaining discourse power within the UN system. For instance, the PRC can rely on a majority within the UN Human Rights Council to defend its positions. The PRC's declared goal is to establish the so-called community of shared future for mankind, Beijing's vision of an international order free of Western biases. The concept was introduced to a global audience in 2015 when Xi delivered his first speech before the UN General Assembly, highlighting 5 aspects which form the core of this vision: equal partnership, a new security architecture, common development, inter-civilization exchanges, and green development. And to implement this vision, the PRC has recently launched 3 global initiatives: the Global Development Initiative, GDI, the Global Security Initiative, GSI, and the Global Civilization Initiative, GCI. And with the GDI, China streamlines its efforts to promote the notion of development over the pursuit of individual human rights at the international level. It reaches out to states from the Global South, many of which share Beijing's human rights priorities. The GSI illustrates the PRC's idea of collective security reform. For instance, Beijing aims to establish legitimate security concerns as a concept in international law. It has pointed to legitimate security concerns when evaluating Russia's war in Ukraine. The GCI puts Beijing's modernization does not equal westernization narrative under a strategic umbrella. This includes a fundamental critique of Western claims of universality. And the BRI is the most comprehensive tool for building this community of shared future for mankind. Legal cooperation as soft connectivity is intended to complement the desired hard connectivity. Directed towards the Global South, the BRI Legal Cooperation Research and Training Program serves to convey and disseminate China's international law practice and legal concepts. The priorities for the CCP promoting rule by law internationally are as follows. First, building international law expertise. We are merely witnessing the first phase of a more self-confident China, which utilizes the law to pursue its interests at the global level. Second, more engagement in international norm setting. The Chinese leadership has identified the high seas, polar regions, cyberspace, outer space, nuclear security, anti-corruption, and climate change as priority areas. Third, promoting foreign-related rule of law. Beijing wants to increase its ability to protect Chinese citizens and entities, and they call it from foreign sanctions, interference, and abuse of long-term jurisdiction, and apply its laws extraterritorially. China is trying to catch up with the United States here, but it has a long way to go. Also, it aims to increase the ability of Chinese courts to domestically apply foreign law. Furthermore, it wants Chinese jurists to better understand and apply foreign and international law at home and abroad. Fourth, increasing international judicial cooperation. Beijing prioritizes international law enforcement cooperation to fight against terrorists, they call terrorists, separatist and extremist forces, drug trafficking, transnational crime and corruption. And Beijing's capability is to pursue its domestic security priorities through the law abroad have grown significantly, but they remain much smaller compared to the US. Fifth, building international dispute resolution mechanisms. With the BRI International Commercial Court, Beijing aims to turn the PRC into an international arbitration center. Also, China wants to increase its role in facilitating conflicts between states. A key tool here could become the Hong Kong-based International Organization for Mediation. To conclude, the international order is participatory by design and built for states to contribute to its development. China's interaction in the UN and other global fora are challenging, but they do not necessarily undermine the system. The PRC acts to a remarkable degree within the system, trying to reform it from within, making it less Western and more Chinese. Decision makers should anticipate and prepare to face better trained Chinese diplomats and international lawyers. Concrete violations of international law by the PRC, there are many, should be firmly addressed through those same mechanisms. Otherwise, there's a risk of undermining the international rules-based order in the attempt to uphold it, or becoming more like China in efforts to respond to China. Inconsistencies of US practice and international law are precisely the narrative the PRC promotes towards the Global South. While the PRC is in the process of implementing long-term agendas in international coalition building to reform the international legal order, the US appears to be inward-looking. Following a democracy versus autocracy narrative will not be enough to build a broad coalition. Merely relying on the G7 will not be enough to set future international legal standards and uphold the international legal order. Therefore, I propose reaching out to third states and to build coalitions beyond the G7. Thank you very much for your attention.
Thank you very much. Professor Bath. I think you may still be muted.
I'm indeed. Sorry. Good morning. Thank you for giving me the opportunity to give testimony on the CCP's promotion of rule by law. I have a number of comments on several aspects of the plan, focusing on civil and commercial law. First, the focus on improving laws and rules for Chinese courts and arbitral institutions in order to be internationally competitive. Secondly, the promotion of the use of Chinese law outside China, and similarly promotion of Chinese dispute resolution institutions and laws to the world. And third, China's international outreach in order to promote Chinese legal, judicial and dispute resolution expertise. First, there are many positives in a program which aims to build up the capability and competence of Chinese courts and arbitral institutions so that they meet international criteria in order to be competitive internationally. The work of the Supreme People's Court and other agencies is in fact very impressive in this regard. I also note that China is far from the only country which aims to be an international dispute resolution centre and actively promotes its institutions. The success of the English courts and arbitration institutions in becoming the fora of choice in major international disputes is a good example of this. An important issue here, though, is that to be a successful international centre, parties must be confident not just in the structure and efficiency of the legal system and the institutions engaged in dispute resolution, but in their neutrality and independence from government and politics. In the case of China, this requires not only the creation of the institutions and the legal framework supporting them, but a well-founded belief by the parties using them that they will operate efficiently, consistently, and neutrally in accordance with the terms on which they're created. Chinese arbitration institutes have made significant progress in attracting cases and building confidence. Notwithstanding improvements in capability and procedures, however, Chinese courts still fail the basic test of independence, given requirements by the CCP that judges pledge loyalty to Xi Jinping and the party, and the ability of the party, higher-level judges and officials to interfere in court decisions. The fiction that business and politics can be separated so as to create a neutral system is surprisingly persistent, but is, I think, not sustainable. Secondly, the idea of promoting the use of Chinese overseas has attracted considerable attention. However, it's difficult to tell how effective the promotion of Chinese law as a governing law in international commercial contracts and transactions has been in practice. Generally, the choice of law for major cross-border projects of the kind that China pursues along the Belt and Road correlates with the choice of the Dispute Resolution Forum and is primarily driven by the financiers and by their lawyers. Other factors are language familiarity, confidence, accessibility of law, and availability of legal advice. Anecdotally, it appears that Chinese law and Chinese dispute resolution is used in loan contracts with Chinese lenders, such as Chinese Exim Bank, and I note that this is something which is quite consistent with international practice. It's also probably used in large infrastructure projects involving Chinese companies, and possibly in related contracts, as well as contracts between Chinese subsidiaries and subcontractors. In terms of dispute resolution, both Chinese courts and arbitration institutions record an increase in foreign-related cases over the last number of years. Cases where there is no Chinese party, however, are few, suggesting that although Chinese fora may be accepted for disputes involving Chinese companies or one Chinese party, they are still not regarded as locations of choice for the purpose of international dispute settlement generally. In addition, Hong Kong, Singapore, and other international arbitration institutes are also receiving substantial numbers of cases with Chinese parties, although it's not clear what systems of law are involved. I also note that there's been a rapid increase in the number of investor-state cases brought by Chinese companies under Chinese bilateral investment treaties, which is consistent with recommendations from the Supreme People's Court and the Ministry of Commerce, and many of these have been brought against developing countries along the Belt and Road. None of them are, of course, being heard in China, but consistent with the China Exim Bank's loan contracts, which require Chinese law and CTAC arbitration when the other party is a sovereign state, Chinese arbitral institutions have been preparing to accept investor-state arbitrations. In my view, an arrangement pursuant to which governments of developing countries agree to Chinese law and dispute resolution, waive sovereign immunity, and have a case against a Chinese government, bank, or state-owned enterprise heard under the auspices of a Chinese institution is very problematic. Finally, where China has been effective is in its investment in outreach aid and assistance and other arrangements pursuant to which Chinese courts and arbitral institutions have been promoting the smart courts, Chinese advances in online arbitration, and other aspects of legal and structural reform. This highlights, I think, the very real need to assist developing countries to build up and improve their own legal and judicial capacity. The recommendation that I would make to the Commission, therefore, is that the US should make it a priority in responding to China's internationalization project to engage with developing countries in improving their laws, judiciary, and dispute settlement mechanisms, and in training young scholars, judges, and lawyers in order to assist them to improve their domestic capability to negotiate and deal with major investments with international parties. I think developed countries have been unnecessarily absent from this particular space. Thank you.
Thank you very much. Mr. Harris.
Thank you. I am an international lawyer who has, for the last 20 years, been helping American and European companies navigate China's legal landscape. I mention this because much of what I'm going to tell you today is based on what I have seen while representing companies that do business in or with China. I will mostly be talking about how the Chinese Communist Party utilizes laws and regulations to maximize its power and control to the detriment of American companies. This is the tactic known as lawfare. I have seen firsthand how China employs lawfare to harm American businesses, and I have also seen how China's lawfare against American companies increased when Xi Jinping became the CCP's highest-ranking officer in 2013, and again when he became president for life earlier this year. The global humiliation China suffered from its botched spy balloons, coupled with our government's efforts to deny China access to leading-edge chip technology, make me confident that China's lawfare against American companies will continue to increase. My clients often ask me about the fairness of China's courts, and my answer has always been the same. If you are suing a Chinese company for breaching a contract to make rubber duckies, you likely will get a fair trial. If you are suing a Chinese company for stealing cutting-edge semiconductor intellectual property, good luck. Many China lawyers call this the 90-10 rule. 90% of the time, the Chinese courts rule fairly because that allows China's economy to function, and that ultimately benefits the CCP. But if a case is critical to CCP power and control, fairness gets tossed out the window. That 10% is lawfare. Xi Jinping often makes clear that China's national security interests are broader and more important than they once were, and that China's economic and investment interests are now narrower and less important. Reading the writing on the wall, writing that in large part has been propagated by state-owned media outlets, the Chinese courts have acted accordingly. This means that the number of cases Chinese judges see as implicating China national security interests have increased, and this has been to the detriment of American companies. Under China's cybersecurity law, the CCP has legal access to any data stored in China. This law also gives it legal access to data held by any company or individual in China, wherever that data may be stored. This has essentially always been true, but with each iteration in the law, access has become more explicit. China has enacted these laws and regulations so the CCP can monitor pretty much everything in China. The CCP only rarely uses its power to mandate that a foreign company turn over its data, but this is because it already has ready access to all data in China. The CCP controls China's internet, its communication systems, and its server farms. The CCP has pushed nearly everything from utility bills to daily communication into WeChat so it can monitor what everyone does in China. It has done much the same thing with company data. Multinationals sometimes file IP theft cases in Chinese courts. If that lawsuit involves rubber duckies, they can prevail. But if their case involves semiconductor technology, they rarely can prevail. The more cutting edge and important the technology, the less likely the multinational will prevail in an IP case in a Chinese court. Multinationals often can sue a Chinese company outside of China. But if a multinational secures a judgment or award outside China and that judgment or award needs to be enforced in China, which is often the case, that enforcement will occur only if it is in the CCP's interest. China's new counter-espionage law expands the definition of espionage to include any items related to national interests, without any parameters for what constitutes national interest. This vagueness is in the law is intended to allow the CCP to arrest anyone at any time. The CCP will use this law against foreigners and against Chinese citizens that are seen as getting too close to foreigners. This will make it difficult and expensive for foreign companies to hire and retain employees in China. In turn, this will reduce foreign company competitiveness in China. China excludes foreign companies from many industries. While we debate banning TikTok, all major U.S. social media platforms are essentially banned from operating in China. If the CCP or the Chinese people are angry with a particular country, you can expect the CCP to crack down on companies from that country. The CCP does not randomly choose the companies on which it cracks down. It chooses companies based on the message its crackdown will send. The recent raids against the Minsk Group and Bain & Company were to send the message that the CCP controls information about China and it will punish those who seek to reveal information the CCP does not want revealed. The CCP will harass and discriminate against American companies until there are no more American companies in China. The best way for the U.S. government to reduce CCP strong-arming against American companies is to help those companies leave China. The U.S. government should provide loans and grants to American companies that move their operations or manufacturing from China to the U.S. or to an allied country. Australia and Japan have done this, and we should too, maybe somewhat along the lines of what we are doing with the semiconductor industry. The U.S. government should also enact legislation that encourages imports from countries that share our values, and we should be doing more to stop American funding of Chinese companies that operate against our security interests. Thank you.
Thank you very much. We will begin the question and answer period going in alphabetical order, starting with Commissioner Borokoff.
Thank you very much. First, let me say that as a business owner and eventually primarily a business investor, not an operator, but for 45 years an operator, it's really delightful for me to have an opportunity to question the lawyers as opposed to being on the other side of the table. Listening to the three of you who all give just great analysis of what's happening, there's a slight difference, maybe a fairly large difference between each of your recommendations, depending on what you focused on. And so I have a question for all three, but I'm going to make a comment about each of them quickly. Mr. Harrison, you mentioned that the U.S., one of your friends said, and I think you might agree with it or you wouldn't have mentioned it, the U.S. seeks to protect big companies, talking about the courts and how they operate in the countries. The EU seeks to protect its people, and China seeks to protect the CCP. And then you wrap up effectively saying, at least as it pertains to certain industries, eventually we're going to have to see our companies leave China. Dr. Rudolph, you talk more about working within the system, and if we do a little better job of that, perhaps we can make it work. That's my perception. And then Professor Bath, I think you said we should spend a lot of our time teaching other countries how to do a better job. So my question is, as a guy who's been on the receiving end, not from China, in no involvement with China, but as a business owner, there's a lot of litigation that goes on in any business. In fact, since 1987, not a single day has gone by in my life that either an entity I own or invest in is being sued. I'd like to hear each of yours, how you would respond. Do you agree or disagree, starting with you, Dr. Harris, you might expand on it a little, that dependent upon the industry, we should be encouraging our government to help people just not do business in China?
First, I would like to clarify. I think that I said that quote about the US, the EU, and China, I believe that was with respect to data protection and data privacy, not the courts. I am not slamming the courts, the US courts here today in any way.
Okay.
Well, as I was listening to Dr. Moritz talk, what popped into my head is I believed every word he said because I've seen it. But if I hadn't seen it, I would think he's a crazy conspiratory theorist. People often compliment me on being able to predict what China will do, and I say it's actually very easy. I just look at the worst thing possible. And so, and you're hearing this from someone who back in 2010, 2005, was a big believer in China, but I've seen a big shift there, and I do not see things ever getting better. I see things only getting worse. And that is why I think that the threat is so dire. And I do not think this idea that we can work with China to get them to change their views, that's not going to happen. That's just my view.
Thanks. Dr. Rudolph.
Thank you so much. Yeah. Well, I think it is important. Like my approach is like this. I read what the official documents say, and I think it is important to explore the rationale where another country is coming from. And if it is like a party state with a Marxist tradition, then it makes sense to brush up on this approach as well, because otherwise it will be just words, and you will be only able to interpret them once they are facts. And I think this applies, I think, for for other Western democracies as well. So I just wonder, for instance, if we say that we want to uphold the rules-based international order, and part of the international rules-based international order is the WTO. So there's an idea behind US or European approach how to deal with other countries. And of course, if one party of this breaks it, this order, does the order itself disintegrate? Or is this a violation of this? And then you should seek for mechanisms to fight against this. So the WTO is actually a mechanism where this could make sense. And I wonder if you were promoting like a more Chinese response to what China is doing, whether you would not just become more China yourself. If you want to have more incentives from free market participants, I know it's a difficult environment. But wouldn't it make more sense to just still work within the system? Because otherwise, I don't think that what we have now, we will ever get anything as good and as much accommodating US or European interests as this existing order. The other one that is building around us at the moment will be a much tougher, more difficult environment. So it's just in the pure basic interests of the United States itself to work in this system and not draw out of it, looking for other countries which already share the same vision, and surrounding it, everybody else is already building different standards, which in the long term will harm the U.S. interest as well.
Thank you. Professor Bath, we're running out of time, but I do want to hear your answer. You're on mute. Mute. You're on mute.
There are so many facets to these various questions. I mean, I was in practice in a long time working in China, and I believed for all that time that if we continued to engage with China, that China would become more outreaching and more open to the world. And in fact, the advent of Xi Jinping meant really that my expectations were disappointed in that regard. It's become increasingly tied up in its own concerns and looking inwards. In response to your question, it's difficult for me to say because, of course, a lot of Australian investors have pulled out of China, and we never had the sort of investment in China that the US did. However, our own experience in being the target of Chinese trade sanctions has taught Australian businesses that it's a big mistake to depend entirely upon China. You always have to have your alternatives, and you have to have your alternative markets lined up, because certainly the Chinese government has shown that notwithstanding WTO, it can and will impose unofficial sanctions if it feels so inclined for political reasons. In relation to your question of whether governments should be helping companies pull out of China, I mean, on the one hand, that's a business decision. On the other hand, I agree actually with Dan Harris that in relation to anything that involves high and sensitive technology, China is a very risky place to be, and it's going to be a risky place for some time in the future. And that's the sort of sector which should probably be considering whether they would be better off elsewhere.
Excellent answers by all three. Thank you very much.
Thank you. Next, we'll turn to Commissioner Cleveland joining us virtually.
Carolyn? No? Okay, sorry. So if I heard the testimony correctly, systems are broken, and like the WTO, law of the sea, and there should be some effort to work within those systems, but recognize they're broken. Mr. Harris, I heard you say, in essence, the Bain case is indicative of the fact that, in essence, China wants all companies out. And so we should support that process. Professor Bath, I heard you say that China has been expanding in the world, engaging in lending practices that are, to simplify, dangerous because they, in essence, waive sovereign interest by virtue of the fact that it's Chinese law, Chinese arbitration, Chinese interest that are imposed in these BRI contracts. So it sounds like a pretty broken system. I'd like to start with you, Professor Bath, and ask, how transparent are the terms of these loans? We've talked about it in the past, but transparency feeding into the conversation about trying to beat China at its own game. What are the seniority status of loans? How does it work within the context of, usually the World Bank and IMF has seniority? How would you characterize these loans in terms of transparency and fairness against an international standard? Mr. Harris, I'd like to know from you in the context of helping all U.S. companies get out, is that decoupling? Because that seems to be the word of the day. And then if I could also hear about when institutions fail, and I think most of us agree the WTO has failed. We went to court on the South China Sea, and the South China Sea, everybody agreed, but China has been ignoring the results. What do we do when institutions fail? That's for Mr. Rudolph. So Professor Bath, Dr. Bath, if you'd like to go first and talk about the transparency and these countries know what they're getting into, and then is there anything we can do to remedy that?
I'd like to start by saying that actually I wasn't saying the loans themselves were necessarily dangerous.
Right, no, I understood that.
What I was commenting on was the aspirations of Chinese arbitral tribunals to actually have those cases heard, investor state cases heard in Chinese arbitration institutions instead of before a neutral forum. In fact, first, as far as I can see, there's not a lot of public information out there in relation to loans, but there is a study which was done in relation to lending practices by state banks, and they managed to locate a whole lot of loans by China Exim Bank, Export-Import Bank, made to various sovereign states. The one I saw a copy of actually was a loan made to Kenya. Now, it seems to be quite standard practice in that sort of bilateral loan for the law of the lender to apply. That's not just a Chinese thing. And similarly, in terms of the waiver of sovereign immunity, that's actually quite standard too. And in fact, it's something which there's a World Bank document which recommends that you should be very careful to make sure that your sovereign state borrower gives a very comprehensive waiver of sovereign immunity. So it's not something which is just done by Chinese banks. It's probably something which we should be looking at in relation to banking practice generally. But apart from that, finding out exactly what is in all of these Chinese contracts is not something which is easy at all. They're commercial contracts, they're confidential, and the Chinese are not particularly transparent about what they're actually doing on the lending front. If they were, we might find actually that they got less criticism in some respects, instead of being always told that they're actually deliberately entering into what are going to be bad loans. But I think you're right that it would be very advantageous if the loans were transparent and if we could be confident that in fact they were up to international standards in terms of the provisions that they oppose. But there's certainly a certain amount of commentary which says that in Chinese loans, the banks and the other parties are very careful to require very strict levels of confidentiality. And therefore it makes it difficult to work out what's in them and actually what's happening to them.
Thank you. Mr. Harris?
In response to your question about decoupling, that's not a word I like because I don't really know what it means either. Because decoupling, it ends in, I forget what kind of verb it is, but it ends in ing. And in my view, decoupling means decoupling is already happening in the sense that American companies are leaving China, and China is, in certain respects, encouraging them to leave, but slowly. Very quickly, I will say that about a year ago, I asked a large number of our clients who manufactured in China for shipment to the United States whether they would be interested in moving their production to Mexico if it costs 10% more. And every single one of them said yes. And when I tell people that, they say, well, that can't be. Why haven't they done it? The reason companies haven't moved their manufacturing out of China is because they're paralyzed. It's very difficult figuring out the country. It's not an easy process.
Thank you.
Thank you very much for the question. So I think well, we have to define what it means when a system is broken. So if you violate a regulation, if you violate law, that doesn't necessarily mean that the system itself is broken. Like in a criminal legal system, for instance, if I violate the law, that doesn't lead to the whole criminal system being broken. So I think what we see is we have a lot of examples where, for instance, China, but also other major powers violate international law. And this is a problem, but this is nothing new to international law or to the international legal order. But what we can see is when there's, for instance, when it's difficult to work within the system, like when there are stalemates, then the development is usually that you have like parallel structures that emerge. So in the WTO, for instance, where you don't have a functioning dispute resolution mechanism right now, you just like create a parallel structure, which a lot of countries have joined so far. So maybe the US will join it at some point too, because it's just like it's an international organization that is a mechanism that is being built. And in the UN Security Council, for instance, it is blocked, so a lot is moving down to the UN General Assembly. So what China has been doing, and this is, I think, interesting here, is like in areas where they were unable to reform the system from within, they have been reaching out to other countries and forming their own global initiatives, where they gain discourse power and where they're able to project their own ideas and their own visions. So for instance, when you have a debate about how to regulate cyberspace, cyber sovereignty, so China is looking for other like-minded states that share its vision. If you're looking for the global development, security, or civilization initiative, it's the same thing. It's reaching out to other countries, trying to build a coalition as big as possible to have a system that you're having that could be powerful as a norm setter in the future. So that's again the point. So for the United States, if you point to saying there are violations, the system is broken, that doesn't help because the system will be built in another way at the same point in time. You're just losing time.
Thank you.
Thank you, Commissioner Cleveland. Commissioner Friedberg.
Thank you very much. Dr. Rudolph, I want to put to you the proposition that what we may be witnessing is a decoupling in the legal domain. We've talked about it in the economic domain. You make the point that for the CCP, the law is intended to serve the purpose of helping to establish this community of shared future for mankind. So my first question is, what exactly do you think that means? What is the goal? Do you think the CCP imagines that it can overturn and transform the entire existing system of international law and replace it with something that it prefers? Or are they trying to carve out a sphere, presumably consisting largely of developing countries, in which their vision of the law prevails? And then the second question is, what are the implications of your answer to that question for how you think the West should respond? In one response, we should try harder to persuade the CCP of the wisdom of our way of thinking, although we seem to have failed in that. The other would be that we need to strengthen our sphere in which our vision of law prevails, strengthen and try to expand it where possible. I wonder how you would respond to that.
Thank you very much. So like the term community of shared future of mankind, like in the domestic or like within the Chinese space, this has been a term that dates back, like, I think, to 2011. So the Chinese state used to describe this first in its relationship vis-a-vis Taiwan, then later its relationship vis-a-vis the Asian region, and then it became like a global thing. And like a buzzword of Xi Jinping to use in a lot of international forums since, I think the starting point is in 2015. It was his first speech at the United Nations, and it was pretty much China going to the global stage and saying, well, we actually have this global vision that we would like to put forward. And there were 5 points that they mentioned, and a lot of them, I think it works towards like sowing doubt in the like universal claims that we would have, or like how the system, there's a lot of absolute assumptions that we would have, and just like saying that no, in the end, it's just a power projection of Western states, and it doesn't reflect the reality any longer. And this is in line with the Chinese approach to the law, because it's an instrument. And there's no absolute inherent value. It's more about like if the material circumstances change, like it's Marxist, I'm sorry, but then in the end, the function of the law and how it's applied also changes. So it's quite flexible. You don't have this absolute truth, and then you just like have to build your legal system around it. But then for the 5 points are, it's equal partnership. So they say that the existing order with the United States as the main force, it's not equal partnership. So they say they want to do something else. You can make the point, of course, like China is not doing that, but then they say, well, so does the United States, but we build a road. So in the end, and we don't have any conditions. So in the end, it's easier. You just like sow doubts in this regard. Then you have like the global security architecture, the new security architecture. So you have like a new Chinese approach to security in part of this. And I think this is the most interesting point, because it hits the core of the international legal order, is like the promotion of legitimate security concerns as an argument why big states could actually violate the sovereignty of another state or use force. And it is interesting because big countries in the past, they have violated international law because of national security concerns. And China is trying to legalize this, making this not just a violation of the law, but this actually being part of this order that they are proposing. Like it is really wild from, if you look at the UN Charter, of course, but this is what they are pushing forward. The third part is like this common development notion. So this is for the Chinese Communist Party, of course, like it is about the development goals. And since 2017, you have a new principal contradiction, like a new goal for the party. It used to be catching up under Deng Xiaoping, pretty like just to boil it down. And then since 2017, it's more about like redistribution and having like more of this like common prosperity, be it domestically, but also internationally. And this includes like a critique of the focus that we would, like in the United States, you'd have about like the core value of the individual and of individual pursuits and individual liberties. But in China, the goal for human development is more about you need the development and like the core individual stuff. This is not the priority in their approach towards human rights. And this is being promoted through the world, through other countries. They say, well, in the end, if we may have to make a choice, then well, what is more pragmatic? What is actually, what helps, what is easier for those countries to move forward? And then the other part is this civilization, inter-civilization dialogue. And this is quite interesting as well. So all of this is coming out in the past 3 years. So it's really new. Those are the implementation documents of this global community of common destiny. And there, the goal is pretty much to have like this narrative that like the Chinese development path was a modernization without westernization. So everything what you read about Chinese approach to rule of law, Xi Jinping's speeches, there are many references of do not follow Western approaches to the rule of law. They are wrong. This is the narrative. And this is being projected to an international level through this global civilization initiative, saying like you have claims of universality in the West, but in the end, they are just like Western ideas, but you have other countries in the world which will be much more populous and will be more relevant in the future. And why not second guess every single thing that you have from those Western ideas that are an outgrowth of the period of enlightenment? Like this is a Western idea. So it goes towards questioning this. And the fifth part is like the green development. And this is an area, of course, it's in the interest of China, but you can also see it in the interest of other countries.
I'm sorry,
Thank you.
we have a lot of other folks to get to in limited time, so I hate to cut you off, but if we can move on. Apologies, Commissioner Friedberg. Commissioner Glass also joining us virtually.
And apologies, I couldn't be there in person today. I want to start off with Professor Bath. Based on the research that you've done, and you noted in your oral testimony as well about the investor-state dispute settlement and the targeting of essentially opaque predatory loans to developing countries from the Chinese and the Chinese Exim Bank. As Congress is contemplating a number of measures right now that have been introduced by members of Congress on both sides of the aisle around financing, nearshoring, onshoring, what, beyond educating the developing world related to what's really happening here, do you have any advice about how the United States should adjust our financing based on what little we know about the Chinese process and the opaqueness of it? And then both for you and Mr. Harris, do you have a wish list of what you think would help companies move production out of China into other areas of the world to de-risk? I'm not going to use decoupling, Mr. Harris, but to de-risk, because I think Congress is kind of grappling with that now and, looking for ideas.
Okay, and in terms of the loans, I don't know how much evidence we've got to say that the loans can actually be described as predatory, right? It's clear that some of the interest rates are not as low as they're advertised as being, and because the terms are not transparent, we don't know exactly what's in them. I think the thing is that China was there offering the loans when other states were not, and of course, because they were doing it on a basis, this made them a lot more attractive because imposing a lot of the conditions which the World Bank, which the international organizations were requiring in terms of loan finance. So that made it quicker, it made it easier, and it made it available. And so I suppose the first question is that there needs to be a more concerted effort to provide finance on concessional terms, I would say, to countries that actually need it, and to find some way in which to provide it without having too much red tape attached to it, but yet not in such a way that the money is dissipated because it disappears into people's hands, or because it's tied to particular companies or contractors actually moving in there and constructing infrastructure which may not be sustainable and may not actually be useful. The thing is, China has a lot of progress by virtue of the fact that when no one would put stuff into countries that probably couldn't pay back the debt, they were there offering debts. And I don't know whether you respond to that properly by just saying, okay, I know you can't repay it, but I'm just going to lend you the money anyway. But an answer to that has to be found. And I think that really the developed world has a responsibility to be in there and to find out a way in which to assist with development in developing countries in such a way that they don't end up deep in debt, but they also don't find it so arduous and so difficult to deal with that they'd prefer not to accept it in the first place. Now, as for offshoring, I think I will leave that to Dan Harris, who knows a lot more about it than I do.
So I divide companies between those that make money from China and those that save money by manufacturing in China. And those companies that are making money in China they don't need help. They can de-risk by leaving when they're no longer making money, or they can de-risk by hiring lawyers who help them figure out how to lighten their footprint in China and thereby reduce their risks in China. On the manufacturing side, it's more difficult. My excuse for not having any great recommendations is that I'm a lawyer, not a policy person. What I see is that manufacturing in China is super easy. You go to Alibaba, you find 50 companies, there are tens of thousands of good people to help you. But if you need help deciding where do I make my widget outside of China, there's nobody who can tell you, well, Mexico's better than Vietnam because of this, and Indonesia fits here. So companies get paralyzed and it becomes very expensive. And how the government can help with that, I don't know, other than to suggest that they do so, and that involves money and organizations.
Thank you. Thank you, Commissioner Glass. So I'm up next, and I want to pose a question to the panel. When we're engaging in trying to understand Chinese legal theory and China's legal system, are we playing on their terms by letting them use ours, legal terms of ours, without pushing back? A panelist that we'll hear from later today talks about this within the context of anti-suit injunctions, describing it in the use of that phrase as somewhat of a linguistic sleight of hand, which is intended to normalize what they're doing and their bad behavior by using Western legal terms of art and Western nomenclature. So are we letting them do that? And is it a matter of will? Or, Dr. Rudolph, to your point earlier this morning, is it more attributable to a lack of fundamental understanding of their legal system and the traditions upon which their judicial system is based? And I suppose I'll open it with you.
Thank you very much. Sorry for a long answer. Last time my clock isn't working, and I just saw this here. Okay, but sorry about this.
It's okay.
Well, I think when it comes to the practical dealings, in many cases, it really doesn't matter what the function of the law is, because it's an abstract thing. So there are many cases where it is you can still have a good working relationship. Like in the 80s and the 90s, when a lot of companies were making a lot of money, they were to some extent also relying on the law. And the difference is that with the change of the principal contradiction and like with the change of the overall environment, the function of the law changes as well. So I think to be aware of this and to understand this is something of key importance for US decision makers. And you need to see that Chinese lawyers, they are building their capacity in their knowledge of their own system, but also the knowledge of other systems. And this makes sense. So in return, it would make sense to have maybe some kind of dialogue and some kind of technical exchanges that just to generate more knowledge that would be useful in the future. Without the dialogue, there would be more surprises.
What I have seen is that American courts and Americans in general and actually people in general tend to think that the world is similar to them. And American judges tend to believe that Chinese courts are similar to American courts, and they're not. And that is due to a lack of knowledge on the part of American judges. And I would recommend an article, a Wall Street Journal article written by, I believe her name is Kate O'Keefe. It is regarding Operation Foxtrot, which I'm sure you'll hear a lot about later today. That's where China uses American courts to go after what they would call Chinese dissidents in U.S. courts. They might sue them claiming that they owe $80 million in China, and the whole thing might be a scam, and it would never occur to a U.S. judge to believe that a government somewhere is bringing a fraudulent case, yet they very well might be.
Professor Bath, anything to add?
I'm not quite sure how to answer that one. I mean, going back to the anti-suit injunctions, I think the point there is that we call those orders anti-suit injunctions because that's what our own courts issue. But in fact, they're not an injunction, nor are they an anti-suit injunction. They're a completely different thing based on civil law. And that's not even so much a Chinese difference. It's the fact that the Chinese Civil Procedure Code actually draws very heavily upon German law, and German lawyers would probably understand it much better. I think there is a general point, though, and I agree with Dan there, that judges or Western judges do actually assume that Chinese courts operate in the same way that they do, because our courts are very reluctant to actually criticize foreign courts, no matter where they are. They could be in China, they could be in Afghanistan, they could be in Kazakhstan. And our courts are generally going to, as a matter of courtesy and of comity, assume that they operate in the same sort of way that, that our own courts do. And this is a really big problem, because if what you've got is one of these commercial disputes, we've had several of these, where essentially the Chinese courts have colluded with one of the parties to cheat someone of their investment, then it's almost impossible to actually prove that in a Western court, because you can't get the actual evidence and the court won't make an adverse finding on the basis of inference and hearsay. And unless you actually change the whole approach of the courts to say, actually, you can look behind these decisions and you're entitled to look behind these decisions, then they're not going to do that, because that doesn't actually agree with the view which we have of the world, which is a world in which we have honest judges giving fair decisions.
Thank you. Commissioner Hilbert.
Thank you, Commissioner Goodwin. My question is addressed to all of the panel, starting with Mr. Harris. In 2020, the DOJ indicted an individual by the name of Julian Jin, who was an executive at the software platform called Zoom. Mr. Jin illegally passed along information of U.S. individuals to the Chinese Communist Party, and without the knowledge of the Zoom CEO or other Zoom executives. As a result of this, the Chinese Communist Party then took action against relatives of individuals based in the U.S. engaging in normal activities that the CCP regarded as a breach of their censorship laws. discussing Tiananmen Square, discussing human rights atrocities against Uyghurs. This was a blatant example of how China is using technology platforms, and specifically its national intelligence law, to export its domestic surveillance and censorship laws to our land. Doesn't this risk apply to any Chinese software platform in the US? Would you recommend a ban of Chinese software platforms like TikTok in the US? And if your answer to the latter question is no, can you describe examples, concrete examples of when the benefits of having Chinese software platforms in the US might outweigh the costs of us forfeiting our intellectual property, privacy, and freedom of speech in the US?
I don't know that I would recommend banning all Chinese software in the United States, but I would recommend banning any Chinese software that could implicate national security and privacy, and that's probably everything. I don't think the U.S. has any idea how much spying goes on through software, and I have gotten calls from serious people at good-sized American companies, computer people, engineers at those companies who have told me things that go on at those companies. I have run them down. I have worked with class action lawyers regarding the possibility of bringing lawsuits. I have heard so many rumors that are actually, a lot of them are more than rumors about what companies do with the data. And I've seen evidence of good-sized companies in the financial sector that send information to China. And I also have had clients who make Internet of Things devices, smart devices, who have been convinced that the devices that they have from China are sending things back to China. Does my Nest thermostat tell people in China what's going on in my house? I don't know. The access is incredible, and a lot of it is happening by American companies like Zoom that are essentially, or like TikTok, and I don't know what's going on internally at TikTok or Zoom, especially today, but these are American companies that are run by Chinese people, a lot of whom have backgrounds in the Chinese military, etc. And I have no idea the scope of that problem, but I am convinced, based on what I have seen, that it is huge and not well known. There were articles written about pregnancy tests where some of that information was being sent to China. It's very scary.
Thank you, Dr. Rudolph.
Thank you. I'm not an expert in this field at all, so I think if Vivian has more to contribute to this, the only thing I can say is that like the academic literature in China about like the extraterritorial application of its domestic law, which goes into this category, it's pretty much a view of how to copy the United States approach to extraterritorial application of Chinese law. So I think studying this, what the Chinese side is doing there, is definitely of interest.
Dr. Bath?
I think there are a couple of questions here. I mean, one is extraterritoriality. One thing I wanted to say but didn't have the time or to actually say is that in terms of overt extraterritoriality, Chinese laws which extend beyond China are actually expanding in scope. The Hong Kong national security law is a particularly good example of this, where essentially you can be prosecuted for a breach of the Hong Kong national security law, even if you're not in Hong Kong, if you're a permanent resident, which I am myself, and even if you're not a permanent resident. So certainly they're becoming a lot more open about this sort of extraterritorial reach. The national intelligence law, I think, was actually a very clever sort of, there was a lot of discussion with the Chinese saying, no, we couldn't use the national intelligence law to do anything overseas, when in fact I think it's clear that they don't really need the national intelligence law to do things overseas, as we've already seen from this discussion. I mean, I like Moritz, I'm not an expert at all in technology, but it does seem to me that it's not just a problem of whether Chinese companies own particular platforms, TikTok. It seems to me that there are very big problems across the world in terms of the security of our information and the data. And part of it is the fault of our own companies, which ask for and retain a whole lot of data which they shouldn't have and which they don't actually need to have, leaving them open to big data breaches by criminals and by spies. And the other problem is that we've never been particularly careful about the data which other companies hold and which then sell on to other sources. But if you start banning companies like TikTok or other social media companies, you would, I think, get a lot of kickback. And also you're essentially taking away one of the things which makes us what we are, as opposed to a company like China, which has such strict controls over information. So I don't know where you actually strike the balance there, but I think you start actually with a good deal, paying a lot more attention to the question of the security of data generally, not just for TikTok, but for companies generally.
Thank you.
Commissioner Mann.
Thank you. I have a quick specific question for Dr. Rudolph, and then a couple of broader ones for Mr. Harris. You referred, Dr. Rudolph, in your testimony to inconsistencies in U.S. practice, and the answer may be obvious to you, but could you give me a couple of examples? Are we talking about something big like WTO or?
Well, when it comes, for instance, to the high relevance of the sovereignty of other states. Mm-hmm. So in the past, when it was in the interest of, like when it was in line with U.S. security interests after 9/11, there are various examples of the sovereignty of other countries being broken as well. So I think this is one of the examples the Chinese side is referring to. The same goes to like human rights violations. Like the Chinese side, they're pushing out so many white papers, just like listing those inconsistencies, and they're just like being put out right now. But I think this is like the sovereignty, the human rights debate is pretty much like the double standards debate is what is usually the most specific.
Thanks. Mr. Harris, you wrote in your written testimony, you said that foreign companies tend to be shockingly naive. And then you said, I have several theories as to why this is the case, and I would be happy to expound on this if asked. So I'm asking.
Well, I think one theory is similar to the courts. We tend to view other countries as being like ours. That's number one. Number two, under President Trump, the China issue was viewed as a Trump issue. And I would always tell people it's not a Trump issue, whether you like Trump or not. And frankly, I'm a lifelong Democrat. Even President Trump can be right sometimes, and he's right on this. And so a lot of people, especially in places like Seattle, do not want to hear about China because they view that as a far-right issue. That's another issue, another theory. A third theory, which is really not a theory, is that a lot of the people that Americans send to China have deep connections with China. They studied there, perhaps their spouse is Chinese, and they make their money there. And many times, probably 25 times, I've had someone either jokingly or not jokingly call me up and essentially tell me to shut up because what I'm saying could send them home and cost them their job. And these are sometimes people in China who work for companies that I represent. They don't like me giving advice to their home office that, no, this is not a good idea to do this sort of deal in China. Now, you as a lawyer, you get that a lot in everyday transactions. The salespeople, they always want to make the sale. They don't want the lawyer to say this isn't safe. But the problem is American companies tend to believe what they're hearing from their China experts sitting in China, and they don't realize how biased they are. Also, there's the issue of money. This isn't really an issue of naivete, but if things are going okay for you in China, if your widgets are being delivered at a great price and on time, then everything you're reading about Bain & Company or the Minsk Group, that has nothing to do with you, and they can and will distinguish it. But I will say that American companies started getting a lot less naive when Russia invaded Ukraine. That was a big moment where people started thinking Russia's doing these things to American businesses. China could also.
Thanks. I have another question on decoupling, but I don't know if there's time. Maybe I should wait for another round.
Commissioner Price.
Thank you, and thank you all for your excellent testimony. Mr. Harris, I was going to ask you the same question that Commissioner Mann just asked you, but can you just follow on that? If the companies are naive, as you suggest, and your examples are good ones, then how realistic is it to think that any kind of disengagement and companies leaving, how realistic is that really as a recommendation?
I think it is realistic because the bigger companies are not naive. They have people internally who tell them what is going on. And as the big companies start leaving, like Apple moving a lot of its production to India, smaller companies will follow.
Thank you. And also thank you for the rubber ducky doctrine. Now I'll have that image in my head all day. To Dr. Rudolph and to Professor Bath, in your recommendations you talk about engagement. Do you have good examples of where engagement has worked in pushing back on lawfare, or engagement has pushed back, or an education of folks in other countries has worked?
Well, I think you just need to look into the past of educating of lawyers from developing countries. So most of the lawyers that you see, like, were educated and are still educated in French universities and British universities and in US universities. And this, when it comes to having an idea about the rule of law, this is relevant and this matters a lot. So with China reaching out with its legal training programs, having people from the treaty-making departments, from foreign offices, from several developing countries. So this, of course, has an impact. So the training could be either having, because there's existing frameworks, and I know in the German case that is the case. In the US, I'm quite sure it is the same. So having those training seminars with the representatives that will be dealing with China in the future, that don't have the legal tools, that don't have the legal knowledge. Like, this is something, if you don't do it, then you're just losing so much of an edge that you have at this point. And this is a concrete, this is a systemic, concrete advantage that the United States, especially through its universities, still has.
What about engagement in international organizations?
Well, I think when it comes to having an international standard set, you can do it by yourself, or you can do it with other countries. So let's go to the digital sphere, for instance. Like you have the, like in Europe, you have the data security regulation, data protection regulation, which is really complex. It was so complex that the German government wasn't even able to have it on its own website once it was launched because they were violating it. You have a Chinese version of that. And the question is, what kind of law will you be promoting then? What will be the international standard? What is more operatable in the future? So if you reach out to other countries in the global south, and if you're trying to get like a discussion of operationalizing it and getting this into practice, this is an issue. Another concrete example is, for instance, when it comes to getting majorities in the Human Rights Council, in the UN General Assembly, like those things matter. If there's something like when the national security law in Hong Kong was passed, like Western states didn't have a majority of countries denouncing it. So this is a problem. Like you need to be at least on this like the core of this international system. Like those majorities, the discourse power that revolves around this. This is relevant.
Thank you, Professor Beth. Do you want to add anything?
Well, Morris has actually said a lot of things that I was going to say. I mean, certainly in terms of engagement at the international level, I think we suffered a great deal from essentially the US pulling back during the Trump era. I mean, China has a lot of people, they're all running around, they participate in everything. And so you really have to push back on that by being there yourself. So you really have to send more diplomats and more people. It's not just the US, Australia and other countries have to do that too. I mean, I think myself that engagement with China has actually had a number of productive things. I was first in China when I was a student there at the end of the Cultural Revolution, when there were no lawyers and there was no law. And for a lot of the time when I was practicing there, nobody understood anything about law because they didn't know what it was. And now, even though obviously there are a lot of problems with the law, there is a legal system, there are judges, there are Western-trained lawyers and people working in the judiciary and so on. And I think that they have an impact. It's certainly better than being the sort of Cultural Revolution lawless place that it was before. I mean, the point of my recommendation in terms of training, as Moritz sort of really covered it there, the thing is, if you're looking at developing countries along the Belt and Road, and China has been promoting Chinese law, as we've seen from the rule of law, and trying to promote China as a dispute resolution centre, the answer is not to get in there and say, oh, well, let's have US law or UK law or whatever it is. The answer is to have a whole lot of lawyers and judicial people and laws whereby the country can actually build up its own domestic capability and have its own negotiators and people who can negotiate with whoever comes along, offering them finance or offering them major infrastructure contracts and the rest of the things that they need to actually develop. And so the point is the Chinese are out there actually promoting, I mean, some excellent initiatives that they have, like they're very well ahead in terms of, say, online arbitration and online litigation. But the rest of us should be out there as well, sort of engaging in training and assisting them to build up their own domestic capability along the Belt and Road, so that it's not a choice between Chinese law or UK law, it's their own law.
Thank you so much.
Commissioner Shriver.
Thank you, Mr. Chair, and thank you to our witnesses. Really fascinating discussion. I have a couple unrelated questions, if there's time. First, I'm always interested in how the Chinese are organized to do things, and sometimes understanding how they organize to accomplish things helps us come up with ways to deal with that or counter that or whatever the case may be. And so if we're talking about a legal system and a judicial system that is to understand this 90-10 split you described, has to make some assessment of which cases fall into that category of this is not going to be a straight interpretation of the law, this is going to be promotion of national interest, national security. So can you talk a little bit about, I mean, are these judges that are sort of trained and expected to make that assessment? Is there a political commissar system that are into the courts, or how are they organized to accomplish this?
Okay, I'm going to answer this from my own practical real life experience. Generally, the judges know because there are certain ways they're supposed to rule. So they generally know. But if a lower court judge gets it wrong, then a judge above them will say, hey, you've gotten this wrong. You need to revise your ruling. And my understanding, and this is based on what Chinese lawyers tell me, is that if it's a sensitive matter, they will consult with higher ups on how to rule.
So higher ups is there a party entity or is this something
Well, when you were saying court system, to me, you can call it the government, you can call it the CCP, it is essentially, you can call it the judicial system, it is all one thing. It is not an independent judiciary. The judges are under the CCP / the government.
Okay, thank you. Were you going to add or no? Okay. As I said, a second question, which is unrelated. Several comments about assisting in the developing world and engaging in the developing world. And while I think that makes a lot of sense, that's a pretty big task, extraordinary task when you think of what that could look like in practice. And so I'm wondering, the recommendation, I think it was Professor Bath, Congress should be funding more of this type of engagement. My guess is that even successful initiative, it's still going to be somewhat limited resources. Is there a way to understand prioritization? And you mentioned Belt and Road and what the Chinese are doing, but that strikes me, if we sort of go there, that's a little bit of whack-a-mole approach. Is there a way to, if you had additional resources but limited, how would you prioritize this engagement?
I would think that's actually something in which you probably have all sorts of people in your diplomatic service. You could probably make very good recommendations in that in the US government as to where money would be best spent if you were trying to build up people's capability. I think the countries which are going to need it are probably the less developed countries, possibly those with natural resources which are ripe for people to come in and exploit them. Countries where they need development in the form of infrastructure and other projects, but they also need the capability to negotiate the sort of contracts and the deals which will be the best for them in the context. The World Bank actually does quite a bit of work on this in terms of how to teach people really to enter into sort of your public-private partnerships and so on. So it's not as though it's an area which is totally empty. But it does seem to me to be an area in which the developed states have sort of stepped back and really done it on an ad hoc basis, or perhaps not really thought through where the best places would be. But as for saying what a particular country would be, I couldn't answer that.
I'm going to pop in here and say that Latin America, China is pushing hard in Latin America. The U.S. needs to also push hard in Latin America.
Thank you. I just want to add something briefly on the judges and on the judicial system in China, because I think sometimes we, like to some extent I agree, but to some extent I think it makes it, it underestimates a little bit what China is doing when it comes to the professionalization efforts. So there's some studies of people who analyze the entry exams of Chinese judges, and this socialist, non-concrete stuff is it used to be easier than it is now. Now they're tough tests. So to become a judge in China, it's not an easy task. And there's also work on in the rulings, because a lot of the records, you can watch it, you have the records of judges referring to core socialist values, and there are very few cases of this. So within the system, system itself, there are incentives of applying the law, like because the system itself, they know, like if it is just like an arbitrary system, it won't work in the long run. It is more strategic, and of course there's always like this, it's a socialist system, you don't have an independence of a judiciary, but like when it comes like to the efficiency of the system, professionalization measures, they are very high on the agenda, and you're dealing with very well educated judges there.
Vice Chairman Wong.
I don't really have a question. It's more of an observation and perhaps more of a musing. You know, I look at the Communist Party here and the Chinese government and these legal reforms, which they seem to be undertaking with greater rapidity, but have I guess spent decades trying to bolster their legal structure. And this is a Marxist-Leninist party. And under Marxist-Leninist legal theory, in essence, all law is illegitimate. That it is a reflection of a power base, a superstructure that is meant to entrench the power of the owners of the means of production, bourgeois society, imperialists, whether it's domestic law or international law. And under, you know, the progress of society, at some point, law as a concept should wither away in place of perfect scientific administration. But the Communist Party is not seeing that happen. So instead of letting law wither away, they're trying to wrest control of it. They're trying to play the same game, buying into the idea that, yes, law is illegitimate, but you might as well use it if it is a space for power struggle. You might as well be the one who's winning the power struggle. In doing that, however, I have to think they're very frustrated. They still have to use these Western terms, these concepts, rule of law, constitutionalism, due process. I mean, these terms which just don't mean anything under a Marxist-Leninist theory, but they still try to use them and fit them into what is essentially a party power play at many different levels. You know, to borrow another kind of Marxist term, that's an internal contradiction, and one that I just don't think in the long term is sustainable. In any case, I'm at like a 10,000-foot level here, and it's more of amusing. But just listening to all your testimony, I can't help but have that general feeling.
Yeah, thank you very much. Well, to some extent, I slightly disagree, because I think that like the legitimacy of the law, like when it is before the Communist Revolution, yes, but there are writings to after once the party has taken over, and then you just like this Hegelian idea of the world and this Marxist thinking, it still applies. So what you're describing is before, but since you have the CCP in power, they utilize the law to achieve their development goals. And this is their writings about this. So it is not like this. What you described is a very narrow part of this. And the Chinese side, like the interesting thing about it is that they utilize the law in all of those terms. Like they mean not what they mean to us. They mean something different. There's an instrumental value to them. But this is part of the thinking, that you don't have those absolutes. It is, and it creates a certain degree of flexibility, because you have the complexities of the world. You have like interconnectedness, you have AI, and you don't need to look into an absolute, and then you have to build your legal system surrounding it. You just have your development goals, and to some extent the law can help you to achieve those goals. And of course, you train the judges, because it just like makes sense to have a functional legal system that deletes that way of less and less day-to-day arbitrariness. 1.4 billion people. I live in a rural area. Something happens to me. Oh, I can use an app and I can seek some kind of resolution to this, and I don't have to go to an elder. I have a process, and building this process by itself creates a value for the people. It is not the rule of law as you would define it in the US, but the function of it, going by your way, doing your stuff. This is something that the CCP understands. You need to build this somehow. You don't need to believe in this, but if this works, then it's the thing. And in order to work it, you need people who are professional in this regard. You need laws, you need a legal system, you need a structure. And it's not completely arbitrary there. Like, this has been going for decades, but now it's a priority because it's for the global ambitions. And that's why I would take it serious. Thank you.
I agree with what Dr. Rudolph said. I remember many, many years ago, one of our lawyers who lived in an apartment building in Qingdao was touting the fact that there was a dispute between two of the neighbors and one sued the other. And they both thought that they would get a fair hearing in a court, and my guess is that they did. And the CCP likes that because it's a tamper on anger. And what they don't like is a lawsuit where they're suing the government or complaining about something that the government did, or an important company and like raising their land to build a factory or something like that. This really does get back to the 90-10 rule, which really is probably more like 95-5. It's just easier to say 90-10. And for most disputes, the CCP likes having the courts there.
Chairwoman Bartholomew.
Thank you very much, and thank you to our witnesses, and my apologies for not being there in person. I get first, Mr. Harris, the word you were thinking about with ing is gerunds. I'm sure you knew that, you just forgot. But I guess I want to take it up another level and follow up on Commissioner Friedberg's question, which is, what does the world look like if we move from a system of rule of law to a system of rule by law, right? We know that laws are supposed to, frankly, shape behavior as well as providing recourse. And, I'll just preface it by saying that I think, for me at least, the question about the whole international legal system is the fact that Russia is, just destroying Ukraine as much as it can, and the global legal community there isn't anything that they can do to stop it. So sort of there's a question about the utility of international law. But if the CCP succeeds in sort of displacing the system that we have, not of individual laws, but of the concept of rule of law with rule by law, what does that look like? This is for any of our witnesses.
Well, I think the first point is, like, if you have a war, this is a violation of international law. And international law is once the war is over, then you have then you can work through the process, and the people and the states that have violated international law, they will be held accountable in the best case of this. So this is the same thing. If you violate a rule, that doesn't mean that the rule itself is meaningless. Otherwise, you wouldn't have any criminal law. In addition to that, like the difference between like rule of law and rule by law, and the definition of what is rule of law, there is none. It is really difficult. So the rule of international law, there were debates at the UN. I think it was initiated by India in the 50s. And so in the end, like this is a discussion that we should have, I think, because it's relevant. There are different approaches to it. If you define it from Germany and the United States, in other countries, I think it would be quite interesting if we would come up with the same definition, because there's different legal traditions and different values and different approaches to this. So the UN system by itself, it can accommodate different approaches to the function of the law, because when it was founded, the UN, this was already part of the reality, because you had the Soviet Union sitting at the table, and they also had a socialist approach to the rule by law. So in the end, the system can deal with this. It is about to operationalize the relationship between states that have a different view on this. This is precisely what the international rules-based order is about. It's not about having one idea and everybody follows suit. Then it just doesn't reflect the reality and the intentions of the UN-based system.
But Dr. Moritz, don't you think that perhaps that it is the goal of the CCP to displace that system completely, not to work within it to make it more amenable to its own viewpoint, but to displace it?
I think they know that they can't do it, Because look at the reality of like the China's approaches to using law. They're trying to emulate. They're trying to do it how the U.S. does it to some extent, especially when it comes to the extraterritorial application of the law. So they know they are not there yet. And so like this idea of this China is getting to the center and replacing everything, and then we are like in like a comical version of a tribute system. Like this is not the reality I think that we are moving towards to. We're more moving towards to a situation where you have other countries which have a different opinion on fundamental issues challenging the assumptions of a country like the United States. And they're not alone there. So finding some kind of common ground with this, I think this is more practical and more close to the reality than just a light switch. And then we are in a world where the nation state doesn't matter. Like this is a process, and the international order is evolving all the time. So it's even if it, and I don't like, they do not say that it's intention, and I don't think they're capable of doing it, and I think they know they're not capable of doing that in this way that you described it. It would be scary, but I just don't see this happening.
Do our other witnesses agree with that interpretation?
I would say in relation to at the international level, I mean, international law is always evolving, and it certainly means that you can undermine or you can change laws which we thought were generally accepted, if no longer generally accepted. But China's not the first to do that. You have the Group 77 and all these other people trying to change assumptions with some success. I think China in the international sphere is more interested in particular laws. So undermining, for example, the regime of the law of the sea in relation to the South China Sea, undermining the international consensus with some success in relation to human rights law, for example. So not actually destroying the entire system, but actually sort of having its input in how it has shaped to shape international law going forward. And going back to your question to what does rule by law look like, I think China and Russia give us a good example of what rule by law looks like. That is, you have a legal system, but essentially the people on top are in charge of it, so that your dissidents and other people can be put away without any particular difficulty or any trouble.
Mm. Thanks. Mr. Harris, any closing?
I agree with what both Dr. Bath and Dr. Rudolph said.
Thanks very much.
Well, thank you all very much for your time. We're going to take a quick break and come back for our second panel at 20 after the hour. Thank you.
Our second panel will describe specific case studies of China's violation of international legal rules and norms, how it was attempted to distort international law to justify its actions, and the consequences for the international legal system. First, Isaac Cardin, Senior Fellow for China Studies at the Carnegie Endowment for International Peace, will address how China uses international law to assert its maritime policies. Second, Brian Whedon, Director of Program Planning for the Secure World Foundation, will address how China interacts with international space governance. And our third panelist, Paul Shari, Vice President at the Center for New American Security, will also provide a case study on how China interacts with international law in the cyber domain and report on China's attempts to set norms related to artificial intelligence. Our final panelist, Ms. Chen, Assistant Professor at Academia Sinica and an affiliated scholar at the U.S. Asia Law Institute of New York University School of Law, will address how China has used Lawfare to target Taiwan. Thank you all very much for your testimony, and I'd like to remind you to keep your remarks to 7 minutes. Ms. Cardone, Mr. Cardone, we'll begin with you.
Thank you to the Commission for inviting me to speak with you again. It's an honor and a great opportunity to share my research and analysis with the legislature and the general public. I'm going to concentrate my delivered remarks on my policy recommendations and just briefly highlight some of the major elements of PRC influence on international maritime law and order. I'd refer you to a long book that I've just written on it for more details on these specifics, as well as what I've put in the testimony. It's China's Law of the Sea. So on the question of whether China is trying to change the rules or make new rules and how they do it, I argue that the PRC's domestic law enforcement and policy implementation in disputed maritime zones is the practical method by which China seeks to change maritime rules. And here I'm talking about the law of the sea as the primary body of international rules that are affected by these Chinese maritime practices. These maritime disputes demonstrate where China's law of the sea diverges from that of other states. And so briefly on the major rule sets that are implicated in China's practice, maritime boundaries and baselines and entitlements are quite a significant area where China has no fully settled maritime jurisdictional boundaries with any of its littoral neighbors. And this is sort of the starting point for what I'm describing as an overall effect of the law of the sea not being applied in East Asian littoral with nearly as much effect as we might like to see. So it starts with the boundaries and the baselines. We move on to marine resources and sovereign rights over them. And lacking agreed boundaries, regional states are contesting China's asserted jurisdiction and sovereign rights over resources. And what we see in practice is China exercising what we might call veto jurisdiction. Nobody's exploiting the resources in all these disputed zones across the East Asian littoral. This is not just the South China Sea, I'm talking about the Yellow Sea and East China Sea as well. And then as we look into navigation, we start to touch on issues that bear on more directly on U.S. interests, and I'll get into this in a bit. But as a general principle, what we see is Beijing asserts broad discretion for coastal states, the sovereign who's claiming jurisdiction, to regulate navigation of any foreign vessel, to include military vessels. And I want to focus the Commission and the legislature's attention on a particular rule in this navigation rule set on innocent passage through territorial seas, which I think is one rule where China genuinely has some scope for potentially changing a broader rule in international law. But that's an exception. Rather than changing the rules, what I see is China's gradually making the international environment in which those rules take effect, or rather, it's changing that environment rather than the rules themselves. It's narrowing the scope in which the UN Convention on the Law of the Sea applies, as well as the Law of the Sea in general. So moving on from that to policy recommendations, and happy to discuss any of those specific rules and the practices implicated in them in Q&A. But I urge the Senate in particular to ratify the United Nations Convention on the Law of the Sea, as well as the newly open for ratification High Seas Treaty, in order to augment American power and leadership standing in the rules-based international order. If the United States is to succeed in maintaining a stable maritime order, we will have to invest in the law of the sea. The current policy of adherence to customary international law does not meet the challenge posed by China in the present competitive international environment. Our self-exemption from certain binding rules is too legalistic to provide any leadership to the international community. Senate advice and consent on UNCLOS, as well as the new High Seas Treaty, would signal renewed American capability to bolster and rejuvenate the, quote, rules-based international order against cynical appeals to sovereign self-interest from China and Russia. China, despite it all, is a state party in good standing in the UNCLOS treaty framework. This status remains intact even after Beijing's brazen disrespect for the Philippines' 2013 UNCLOS arbitration. Until the United States joins that same treaty framework and becomes subject to the same risk of unwanted arbitration, we will lack legitimate standing to criticize the PRC. The audience for that foreign policy choice should be the wider international community. The U.S. message that China is, quote, violating UNCLOS simply does not resonate with many vital nations, which have hardly failed to recognize that America has not even ratified the instrument. Indeed, critical foreign observers perceive the United States as serially violating those elements of the treaty we do not accept or like. This is an unfortunate and unnecessary liability for U.S. power, which can be exercised more effectively over the long term within multilateral institutional restraints like UNCLOS. Acceding to the mild discipline of the law of the sea would cost little and achieve significant momentum in long-term strategic competition with China. The PRC has proven adept at achieving, quote, paper compliance with its various legal obligations, and it's championed majoritarian organizations like the United Nations General Assembly and multilateral treaties like UNCLOS that the United States now shuns. However, China's rapid industrialization, rapacious demand for ocean resources may push China out of step with new developments in the international law of the sea regime. The PRC's distant water fishing fleet, its deep seabed mining industry, and, of course, its blue water navy risk reenacting some of the, quote, maritime hegemony that an earlier generation of Chinese diplomats reviled. Beijing's post-colonial branding may not survive its desire for minerals and hydrocarbons from the seabed, fish from the water column, and access to strategic maritime areas. All of those issues are implicated under the law of the sea as well as the new High Seas Treaty. China is running some risk of falling out of step with that and having less influence on the rules, but the United States is not going to be effective in shaping that international environment without acceding to the legal instruments that govern it. The United States can seize the high ground in this emerging competitive arena by ratifying both UNCLOS and the High Seas Treaty at the earliest opportunity. I have some further remarks about how we should scope our policy and de-emphasize freedom of military navigation and focus on the marine resource rights and interests of states that are in dispute with China, but I will withhold those comments as my time is running to a close. But I thank you for this opportunity to testify and look forward to our discussion.
Thank you. Mr. Whedon.
Thank you to the Commission, the Commissioners, and the staff for the opportunity to participate in this very important hearing today. My oral testimony today and the written testimony provided earlier addresses the current governance framework and institutions for outer space and China's views on them. It focuses on how that framework enables or constrains China's space activities, where China's interests and those of the United States align or differ, and provides policy recommendations for Congress to address these issues. My testimony reflects the aggregate knowledge and insights from across Secure World Foundation's staff. Our perspective in this matter is informed by two main bodies of evidence. The first is China's actions and statements in multilateral diplomatic space fora, primarily the United Nations Committee on the Peaceful Uses of Outer Space, COPUOS, and the Conference on Disarmament, or the CD. As a non-government organization, we are a permanent observer to these bodies and have either observed or, in some cases, participated in many of these discussions over the last decade, giving us firsthand experience on how China views issues related to space law and norms. We also have had direct experience partnering with Chinese academic institutions and NGOs to organize workshops and discussions on topics ranging from space debris and space sustainability to space security and, more recently, commercial space. Based on this evidence, our conclusion is that China has not sought to wage the same lawfare against the international space law framework and institutions as it has in the other domains, such as maritime. We assess this is likely because China perceives the current space law framework and institutions to not be hostile to its interests, and because it is able to play an active role in helping shape that framework. While it is possible that China may choose to break from those legal principles and norms in the future, we do not see strong evidence to support that at this time, in part because doing so would contradict the diplomatic positions China has established over several decades. The existing framework of laws and norms in space constrains China's behavior to the same amount they do the United States or other spacefaring countries. That is to say, to a very limited degree. This is because while there are long-standing international legal principles on space activities, there has not been much agreement on how to interpret or implement those principles over the last several decades. That lack of agreement in part stems from the unwillingness of major space powers, including the United States and Russia, to place more restraints on their own space activities because they have prioritized freedom of action in space instead. China is conducting or planning to conduct many of the same activities in space as the United States across civil, commercial, and national security sectors. China and the United States share some of the same concerns on issues such as deconfliction of space activities and frameworks for how to extract and utilize space resources on the moon and other celestial bodies. There are areas where the United States and China are pushing different agendas, however, and this is mainly in the discussions on space security issues. China continues to push for a new legally binding treaty on space arms control, as it has since 2008 in cooperation with Russia. The United States, meanwhile, has opposed any new legally binding measures on space security since 1980 and has instead pushed for voluntary guidelines and norms of behavior. While the specific draft treaty that China and Russia have been pushing has not gained significant traction among the international community, there is a general shared concern among many states that a norms-alone approach is insufficient to resolve the many issues and concerns regarding space threats and the potential for conflict on Earth to extend into space. 12 countries have now followed the United States' lead in pledging a voluntary moratorium on destructive anti-satellite testing, and a 2002 UN General Assembly resolution supporting the testing moratoriums gained overwhelming support. However, many countries feel that moratoriums are only the first step and that legally binding measures must follow. And there are other security concerns, including uncoordinated close approaches between satellites that remain unaddressed. Our main policy proposal is for the United States to continue its recent efforts to lead in space governance discussions and help shape their development in a way that benefits U.S. national interests. Recent efforts, such as the anti-satellite testing moratorium proposed by the Biden administration and the Artemis Accord developed by the Trump administration, are positive steps in that direction and should continue to have bipartisan support. However, in its efforts to compete with China, the United States should not actively try to exclude China from discussions on space governance. Doing so is only likely to encourage China to shift toward a more hostile stance towards the existing space law framework and institutions, or efforts to develop new frameworks and institutions. The United States should also take steps to directly engage with China on space issues with the following goals: exchanging views on principles and interpretations on key areas of outer space law, developing a better understanding of each other's space sectors, including private sector space activities, and creating mechanisms to deconflict space activities and minimize risks of misperceptions and mistakes that could heighten tensions or spark conflict. Thank you for the opportunity. I look forward to the questions and further discussion.
Thank you. Mr. Shar.
Thank you. Vice Chairman Wong, Commissioner Goodwin, Commissioner Hellberg, distinguished commission members, thank you so much for inviting me to testify today. China is pioneering a new brand of digital authoritarianism at home and abroad, which poses a profound threat to global freedoms. The United States must work with other democratic nations to push back on these illiberal uses of technology and develop an alternative vision for digital technologies that preserves personal privacy and individual freedom. The Chinese Communist Party is building a vast surveillance network to monitor its citizens and control their behavior. These include surveillance cameras, artificial intelligence tools such as facial, voice, and gait recognition, biometric databases, police cloud computing centers, and a national social credit system. The most extreme version of this techno-authoritarianism exists in Xinjiang, where the Chinese Communist Party is carrying out a brutal campaign of genocide and repression against the ethnic Uyghur population. But many of these tools are used nationwide. Many of China's surveillance systems today are fragmented and imperfect, but the Chinese Communist Party is working to improve them. China's initial efforts to control the internet 20 years ago were similarly imperfect. Yet the party has done what many believed impossible, and today exercises an incredible degree of control over the information environment inside China through censorship and propaganda. And the party is working now to extend that same degree of control to physical space. Of course, under China's system of rule by law, there are no legal constraints on the Chinese Communist Party's ability to surveil its citizens. While China has passed several laws and regulations pertaining to cybersecurity, data, and artificial intelligence, the law serves a different purpose in China than in democratic states, and exists to aid the party in governing. This new techno-authoritarianism is a threat to global freedoms because it does not stop at China's border. At least 80 countries have adopted Chinese police and surveillance technology. Even more troubling is the export of Chinese-style laws and norms for governing cyberspace and digital technologies, the social software that underpins this new model of digital authoritarianism. The Chinese Communist Party spreads its model through multiple vehicles, including Chinese ownership over critical digital infrastructure, other countries adopting Chinese-style norms and laws, and Chinese involvement in technical standard-setting bodies. Chinese ownership of critical digital infrastructure presents opportunities for Chinese government surveillance and manipulation of foreign countries. Several countries, including the United States, have banned Huawei equipment because of concerns about spying. Yet Huawei is not unique in these concerns. Any Chinese company can be compelled to aid the government in spying abroad. The Chinese-owned social media platform TikTok presents a threat to U.S. national security because of the risk of U.S. persons' data being exfiltrated to China, and because of the potential for TikTok to manipulate content on the platform. On numerous occasions, TikTok has appeared to censor political content. In 2019, in fact, TikTok's leaked moderation guidelines included censorship of political content, such as that relating to Taiwanese or Tibetan independence or the Tiananmen Square massacre. The Chinese Communist Party knows the power of controlling information. Just as it has controlled information inside China, Chinese ownership over global social media and information platforms allows the party to extend its reach outside of China, censoring content that it deems offensive or against the party's interests. Chinese ownership of a major U.S. social media platform poses unacceptable risks to U.S. national security. Congress should pass legislation giving the executive branch the authority to address threats from foreign ownership in critical information and telecommunications technologies. China has also been active in promoting its norms for governing cyberspace and surveillance technologies. China has held training seminars with over 30 countries on cyberspace information policy. In Tanzania, Uganda, Vietnam, and Zimbabwe, restrictive media and cybersecurity laws follow Chinese engagement. China has also begun playing a more active role in international technical standard-setting bodies, using them as another vehicle for exporting China's vision of digital authoritarianism. Technical standards are an important avenue for shaping global technology development. China's influence in technical standard-setting bodies threatens to spread standards that would enable Chinese-style surveillance and repression worldwide. Congress should increase funding for the National Institute of Standards and Technology, NIST, to ensure it is adequately funded to engage in international standards-setting discussions. Yet it is not enough to push back on the spread of China's model of digital repression. The United States and other democratic nations must work together to present an alternative vision for using digital technologies that preserves privacy and individual freedom. The U.S. Congress has considered, but not passed, a comprehensive federal data privacy law. The United States currently has a patchwork of laws at the state and sometimes local level governing digital technologies, including consumer data privacy and law enforcement use of facial recognition. This patchwork approach impedes innovation. Congressional leadership is needed to create nationwide rules governing digital technologies. Congress should pass a comprehensive federal data privacy law. Additionally, Congress should pass legislation governing AI-generated synthetic media, requiring disclosure to users when content such as text, voice, images, or video is generated by artificial intelligence. Congress should also work with social media companies to establish common standards for combating disinformation, manipulative content, and inauthentic behavior, informed by industry best practices. The United States must also work with its allies and partners to shape global norms and standards. The U.S. State and Commerce Department should work with allies to lead the establishment of a new group of democratic technology leading states, a G7+, sometimes called a Tech 10 or T14. These steps are important to push back against China's spread of its model of techno-authoritarianism and will help ensure that digital technologies are used consistent with democratic values. Thank you.
Thank you. Ms. Chen.
Distinguished members of the Commission, thank you for inviting me to this hearing. In response to the Commission's questions, my testimony today will mainly address China's deployment of legal warfare as a coercive tool to compel Taiwan into compliance. I will focus on three aspects of China's legal warfare against Taiwan: international, domestic, and within Taiwan, respectively. The first aspect is international, that is, China's efforts to isolate Taiwan within international organizations. The CCP government has been manipulating its own One China principle, which asserts that Taiwan is part of China. Beijing has sought to conflate this assertion with international norms. This approach aims to exclude Taiwan from the international system, thereby creating the impression that questions regarding Taiwan are solely China's domestic affairs. China's push to confuse its own claim on Taiwan with international law, if successful, would be useful to Beijing in the event of conflicts across the Taiwan Strait, which China would almost certainly claim to be an internal war rather than an invasion to annex Taiwan. The most striking example of this tactic is Beijing's campaign to conflate UN General Assembly Resolution 2758 with Beijing's own One China principle. For example, after Speaker Nancy Pelosi visited Taiwan last August, China issued a white paper on Taiwan, asserting that, quote, Resolution 2758 is a political document encapsulating the One China principle, whose legal authority leaves no room for doubt and has been acknowledged worldwide, unquote. Such claims are false, as discussed in my written testimony, yet Beijing continues to propagate its misinterpretation of the resolution. This persistent practice, verging on misinformation and disinformation, renders the UN and its specialized agencies such as the WHO more susceptible to Chinese legal influence. The second aspect is Chinese domestic lawfare initiatives targeting Taiwan. China's most notable domestic lawfare against Taiwan is the 2005 Anti-Secession Law, which authorizes the government's use of force against Taiwan under the law's vaguely defined circumstances. Suppose any further move is made in China towards conducting legal warfare against Taiwan. In that case, it's more likely to be done through punishing those deemed unwelcome by Beijing. In fact, since 2021, the Chinese government has published lists of so-called Taiwan independence diehards and their affiliated organizations. The current sanction lists cover prominent Taiwan officials of the ruling DPP. These lists seem to be aimed at creating deterrence and a chilling effect within the broader Taiwanese society. This brings me to the third aspect of my presentation, which is China's attempts to employ lawfare within Taiwan. Taiwan has maintained its rule of law as it remains beyond the reach of China's law enforcement. However, Beijing can still pressure Taipei politically and economically by breaking their bilateral agreements. Since 2016, Beijing has deviated from or bluntly violated multiple cross-strait agreements when it appeared politically convenient to do so. For example, China has unilaterally terminated the communication channels specified in these agreements, making it challenging to resolve disputes arising from them. In light of Taiwan's upcoming presidential and legislative elections in January next year, we should anticipate an escalation of such tactics. In conclusion, I'd like to highlight a number of recommendations. First, China's misinterpretation, misinformation, and disinformation regarding its One China principle must be countered. Resistance against Beijing's campaign would be more effective if it were initiated by influential democracies such as the United States and its allies, rather than solely by Taiwan. These endeavors would be useful if they concentrate on international organizations that Taiwan aspires to join as an observer, but have been rejected for its meaningful participation based on the international organization's false premises. Second, Beijing's resurgence of economic coercion by way of violating cross-strait agreements indicates an intention to influence the political choices of the Taiwanese people in the upcoming elections. Taiwan has sought to diminish China's economic leverage against Taiwan. Such efforts to enhance Taiwan's economic resilience can be bolstered by countries signing trade agreements with Taiwan and advocating for Taiwan's involvement in multilateral economic institutions. Lastly, enhancing the understanding of Taiwan and its unique perspectives would ensure that U.S. policy is thoroughly informed and well-rounded. Therefore, I thank the Commission for this opportunity and look forward to the questions.
Thank you. We'll start in reverse alphabetical order with Vice Chairman Wong.
Thank you. Dr. Cardin, you used the phrase to describe China as being a state party to UNCLOS that is in good standing in UNCLOS. Is good standing, is that a status under UNCLOS, like actually in the convention?
Not formally, but they've ratified the treaty. They haven't been ejected from the treaty, and you'll note that the UN Convention on the Law of the Sea process encompasses much more than individual arbitrations and even China's maritime disputes. This High Seas Treaty that I mentioned, for example, is under that framework. China was a leader in the development of that treaty, which is now open for ratification. So what I was trying to emphasize is that despite, from our perspective, them disrespecting the law of the sea arbitral mechanism, they remain within the treaty. And the irony is we are not subject to that same discipline. We couldn't be sued under the law of the sea arbitration, dispute resolution mechanisms. There couldn't be an arbitration against us. And I think that's the key observation that I want to leave with you.
But I mean, to put a finer point on it, are there any party states or state parties to the convention that are not in good standing in your view?
No, I think I chose that rhetorically, which is to say they're a member of the treaty organization. They haven't been ejected from it. And
is there a process for ejection?
I don't believe so.
So no matter what, anyone who has signed and ratified the treaty is in good standing. There's no such thing as not good standing, right?
I suppose not in a formal sense, no.
So I make this point to say, it is odd to me. I understand the focus on UNCLOS, but the fact that China can be a quote-unquote in good standing, there's no official line between that. It makes me question the value of UNCLOS if China, with its violations and its disrespect, and the number of efforts that you list in your fine testimony to undermine the customary international legal rules that are acknowledged by the international community, that it can remain in good standing. I just find it somewhat ironic. Moving on to another topic, I agree with your recommendation that we have to not just do FONOPs. I think FONOPs are important. We should do that. We should do in conjunction with our allies where possible. they are resource heavy and they can't be the only effort. But as far as joining with our partners and even non-partners in their maritime claims that we find meritorious, are there specific examples of that? Taking up actual legal arguments in certain arbitrations, absorbing it into our policy? Are there specific claims that you think are very meritorious that we should join up with?
Thank you, Vice Chairman. Just briefly on that last point, I think you're right to say this is the fact that China can engage in what we could characterize as violations of rules and norms written down in black letters in the treaty and yet remain in that framework is problematic. But I'd just put the question to the United States generally as a matter of strategy is if we're investing in rules-based order, are we more effective within or without that treaty framework? And I would argue we certainly are. On this question of de-emphasizing FONOPS and focusing on some of the resource claims, in particular of claimant states, again, this would be done much more effectively from within the UNCLOS framework, which is to say, under UNCLOS, let's take a very specific example. Mischief Reef, where China has built significant military and Coast Guard facilities, is on what under basically any reasonable interpretation of the law of the sea treaty, it's on the Philippines continental shelf. It's a submerged part of the seabed, and it's well within the continental shelf. Any activities around it should be governed by exclusive economic zone rules to include fishing, oil and gas exploration, et cetera. We could be quite specific on that count, and we would be more effective in making that argument, again, if we were making that argument from a position of strength within the treaty.
Can I ask, when did UNCLOS come into force?
Sorry, say again?
When did UNCLOS come into force?
It came into force in 1994.
And how old is customary international law of the sea?
Arguably, it's the earliest form of international law. I think it tends to be dated to the Roman Empire.
Back to antiquity. So a body of law of antiquity, you feel there are no mechanisms for us to lodge our disagreement with Chinese claims, support the claims of other parties, because we are not within a roughly 30-year-old law of the sea treaty.
I don't believe there are no mechanisms for it. What I would argue is that we're much less effective from without it. Our voice is less meaningful because it comes off as cynical and self-interested and selective, the same things that we assign to China or Russia in their treatment of international law. So I think, again, it's a mild discipline that we accept by joining the UN Convention on the Law of the Sea, and I think it pays major dividends over the long term strategically.
Thank you. I do want to follow up on the specific claims that we think are meritorious, because those would be very good recommendations for us to absorb. Thank you.
Thank you very much. Commissioner Schreiber.
Thank you, Mr. Chairman, and thank you to our witnesses. Dr. Cardinal, I also wanted to follow up on your comment about de-emphasizing freedom of navigation and prioritizing protection of resources. It doesn't occur to me, or it's not obvious to me, that those are mutually exclusive. In fact, I would actually link freedom of navigation with the protection of resources. But I wanted to press you just a bit on, you're identifying a need to de-emphasize. So that would suggest you think our freedom of navigation program is causing us some problems, or creating issues that we would be better positioned, more optimally positioned if they were de-emphasized. So I'd like to just press you on that a little bit more and get your thoughts.
Thank you, Commissioner Shriver. And I think you captured the essence of what I was trying to say. I don't think they're mutually exclusive. It's a matter of emphasis, and I do tend to agree there's some complementarity. I think our interest in maintaining free navigational norms has broader structural effects on maritime order. My argument is that as a matter of effective diplomacy and foreign policy, that's not an interest that's broadly shared. And one of the things that I learned in doing the research from my book is that the United States really is the only one asserting most of these rights, especially in East Asia. The regional states are not.
But isn't that a public good? I mean, who else has the capability to do that?
Well, I I suppose we could have a discussion about who has the capability to do a FONOP. Anybody with a boat, frankly. It's not a very high intensity operation, but it's not in the interest of most of our partners because they are not exercising globally this freedom of maneuver and freedom of action. It's not their strategic priority. It's our long-term strategic priority appropriately. But the question is, what can we do to bring along the other states, especially the regional states, whose support and I would say active engagement in cooperation with the United States in maritime affairs. In order to engage them, we need to focus on their interests, and those are primarily resource rights. And I think that's actually low-hanging fruit for us from a foreign policy standpoint. I believe the FON program should be continued in a low-key fashion, but I wrote in the testimony, American military access will not be denied by PRC domestic law. There are supposed violations of the law of the sea. The practical reality is we'll maintain that access. We can persistently object in a legally meaningful way. The last thing I'll say on this is that it's quite notable that the PRC, their Ministry of Foreign Affairs, as well as some of their organs of the PLA, their public affairs organs, often publicize FONs before we do. And I think there are a number of ways to interpret that. The one I would offer is they're quite happy with this as part of the regional narrative about what's going on because they reinforce the Chinese argument that it's the United States and its allies that are, quote, militarizing the region. This is unfortunate. We don't want that much emphasis on this particular aspect. What we want to focus on is those issues that other states are also interested in, which is to say their own rights under international law.
Thank you. Dr. Whedon, you made a comment I thought was interesting about Chinese haven't waged lawfare in the space domain with respect to the negotiations underway because, now I'm sort of my words, because they're part of the process. And there is a theory, the Chinese feel less bound to a lot of these international agreements because, they were essentially promulgated to them by Western powers who created them, et cetera. But I would still, I'm wondering, are you making the leap then to, they haven't revealed these tactics in the negotiations to date, and therefore we can expect better adherence? Because I question whether that would necessarily result in adherence, because again, our whole understanding, our whole discussion about how they approach the law and obligations related to the law.
No, good question. I'll address it in two ways. One, yes, we are not seeing them. We're not seeing China actively try to undermine or push back against the existing interspace law framework, in part because it's very broad, right? We don't have the same level of specificity and definitions like we have under UNCLOS for all these kind of issues. We just don't have that yet, right? And China is actively participating in those discussions about how do we define what those interpretations are, how do we apply these broad international space law principles, how do we establish norms of behavior, and they are, I would say they are being mostly constructive in how they participate in that, in direct opposition to Russia, who for the last several years since 2014 when they first invaded Ukraine has been very disruptive and very antagonistic in these same discussions. And I take your point, that does not mean China's going to follow international space law and not try to undermine it in the future. I'm just saying at this point in time where there's open questions about how to interpret, about how to apply it, there is very broad freedom of action for pretty much all spacefaring countries. They are not being antagonistic.
Thank you, Commissioner Price.
Thank you, Mr. Chairman, and thank you all for your testimony. Each one of your case studies has offered some chilling warnings. For all of you, my question is, as you each gave your recommendations, they each dealt with engagement and engagement in international forum in one way or another. Are there examples in each of your areas of where the Chinese government has been successful in influencing international forums that we should be lifting right now in this discussion? We could start anyway, Mr. Shah.
Yes, thank you. There are several, I think, a few that are concerning. One is the spread of Chinese-style laws and norms for cybersecurity governments and monitoring information and surveillance inside countries, which are problematic. I also think Chinese engagement in technical standard-setting bodies has been very concerning. So standard-setting bodies such as the ISO, IEC, ITU. There was an incident a few years ago where draft standards coming out of the ITU had Chinese-style standards for facial recognition technology that would include technical standards of things like race and ethnicity in terms of how the facial recognition technology was constructed, which then is enabling the use of that technology to repress minorities, as China is doing domestically. And so I think that's a concerning example of the way in which China's engagement can sort of spread some of these creeping norms globally. Right, absolutely. That's a place where engagement by the...
Reva, we couldn't hear your question.
I apologize. My question was, is that an example of where if the United States and others were more engaged, it would have changed the outcome?
That's right. So in this case, these were draft rules, but this is a great example where engagement by the United States and other democratic countries on shaping those kinds of standards is vitally important to changing what the outcome will be.
Thank you, Mr. Whedon.
Yeah, so turning to the space context, off the top of my head, I can't think of any Chinese proposals that gained significant tractions were adopted. But I want to highlight quickly three kind of themes I think they have been successful in. So I mentioned in my oral testimony this treaty on the prevention of placing weapons in outer space they've been pushing. While the treaty itself has not got a lot of steam behind it or countries rushing to support it, the theme of some sort of legally binding restriction does have a significant amount of support among the G77, among the global South. I would say more support than the traditional US approach of we don't need anything on here because there's not a problem here. And so in that sense, China's approach has garnered a little more acceptance among other countries than the US's position, even if their specific proposal has not yet gained acceptance. The second thing is I mentioned the Artemis Accords, which are a set of principles the Trump administration put together in discussions with 8 other countries to go along with our program to return to the moon. And those countries that want to participate in return to the moon have to sign on to the principles, but you can also just sign on the principles themselves. There are now 23 countries as of yesterday that have signed on, the latest being the Czech Republic. And they include countries like Rwanda and Nigeria and the UAE and Saudi Arabia and Mexico, definitely some non-traditional US-based partners. China and Russia have since created what they call the International Lunar Research Station, ILRS, which is they're attempting to have kind of their own separate program. They are in discussions with other countries about joining that. So far, none have publicly joined. We've heard rumors about Venezuela, maybe a couple of others are discussing there. And they've talked about creating their own set of principles to go along with their lunar program, but they've not yet made those public. So at least on that part of it, the US proposal has gained significantly more traction.
Mr. Cardin, anything to add, or Ms. Kim?
Yeah, mindful of time, I'll just say briefly, I think that High Seas Treaty that just opened for ratification in March is a very clear illustration of precisely the phenomenon that you're interested in. And I'd call attention to one particular norm in that and its convergence with a Chinese preferred norm that we see across the board. I heard it discussed in the panel this morning, this community of common destiny, 人类命运共同体, is a Chinese ideological position about international order, rules, and norms, and it, I believe, is quite similar in substance to this idea of the common heritage of mankind, which is enshrined in the Law of the Sea Convention, as well as in the New High Seas Treaty, and has implications for space and for cyber domains. And I think if we're not in the room shaping how those norms are interpreted, because they're quite indeterminate, we're going to be losing a very, very important opportunity to be shaping future regimes and, in fact, the practice of these rules in maritime space as well as outer space and cyberspace.
Thank you. Ms. Kim?
I'd like to answer the question if there's still time. Either as a server or as a full member. So even if we're just talking about Taiwan's meaningful participation, that doesn't involve the question of statehood. China has been very successful in serving the gatekeeper role in the UN and its specialized agencies such as the WHA and ICAO. So I think there's a lot of misguided legal opinion in these organizations that must be corrected in so as to allow Taiwan more space to participate. Thank you.
Thank you. Commissioner Mann.
Thank you. My first question is for Yu-Jie Chen. I'm interested in the experience. There have been so many people and companies from Taiwan operating on the mainland. What has been their experience overall with the court system? And there was a recent highly publicized case of a Taiwan publisher arrested in Shanghai. I don't know whether that was a first of its kind case or whether there have been many others like that.
Thank you, Commissioner Ren. I don't think we have a full understanding of what's happening to Taiwanese people and businesses operating in China currently, but we do know that the space is constricting. So the case that you mentioned is just one of a series of cases of Taiwanese people detained in China. And I think we can trace this tightening censorship of Taiwanese people back to the case 5 years ago, more than 5 years ago, NGO worker in Taiwan called Li Mingzhe. When he went into China in 2017, he disappeared from the public view, and days later, we only knew that from the televised announcement in China that Mr. Li was already under detention for suspecting of engaging in activities endangering national security. And this case, the current case of the publisher, Guza founder, Li Yanhe, he was also has been detained also under suspicion of endangering national security. We don't have a lot of information about this case because China has, as I mentioned in my testimony, cut off the communication channels in cross-strait agreements. So even if we do have agreement with Beijing that says Beijing should notify the Taiwan authorities of such detentions and facilitate family visits, such things did not happen in Li's case or the current case of the publisher and a series of other cases of Taiwanese people detained in China, including a pro-Taiwan independence activist. So we are concerned that the new case would create a chilling effect among the broader Taiwanese society. And I do think these cases are designed strategically to show that the DPP, current ruling DPP, cannot help Taiwanese because the communication channel has been cut off, and therefore we do not have further information about these cases.
Thank you very much. A very different kind of question for Mr. Shar. I don't know the issue. You spoke of China's efforts to, in the field of technical standards. and you mentioned the NIST case. Can you give an example of what you mean? How is China trying to change things through technical standards?
Sure, thank you. So there's two kinds of ways that China is throwing its weight around in technical standard setting bodies that can be problematic. So we've seen the Chinese government become much more involved in these technical standard setting bodies, working with Chinese companies behind the scenes, getting all of the Chinese companies on the same page. These are intended to be technocratic bodies where companies get together and they decide on the best standard for something like wireless networking so that all these different devices are interoperable. Well, the Chinese government's been working with Chinese companies to get them all to work together to then have a coherent voting bloc, partly for economic advantage, to give economic advantage to Chinese firms, but also in some cases to push their sort of expectations or norms about how to use the technology, for example, to facilitate surveillance.
Thank you. That's all I have. Thanks.
Thank you. My question is for Mr. Shah. I have a few rapid-fire questions for you. We all know that China has been using technology to export its norm and values and laws abroad. So my first question is, should the United States consider a full ban on TikTok in the United States?
Yes, I do think that the United States government should either ban TikTok or ideally force a sale to a U.S. company to resolve the concerns about Chinese ownership over TikTok.
Should the U.S. government consider restricting outbound capital flows to China in highly sensitive technology verticals, particularly in venture capital, where we've seen firms like Sequoia Capital invest in Chinese artificial intelligence?
There should be some controls, and there are some that come on the heels of the CHIPS Act, for example, for companies that are taking subsidies there. I think there certainly should be controls surrounding end user and end use restrictions. So things like we've had examples, unfortunately, over the last several years of investments from the United States into Chinese firms that are then implicated in human rights abuses. And that's certainly a problem.
Given that Chinese technologies end up flowing back to the PLA, what would be a use case of where an American investment in a Chinese artificial intelligence company would actually be a valid use case in the interest of the U.S. government?
Yeah, I certainly don't think that we should cut off all entanglement between the United States and China on technology. I think that we need to have restrictions surrounding military end users or end use and connections to human rights abuses. But for things like basic research, that's beneficial, and in part because a lot of the talent flows the U.S. benefits disproportionately from. China's best and brightest AI scientists and engineers actually don't stay in China. They come to the United States for graduate studies, and then they tend to stay here after graduation. 90% of U.S. or Chinese students that come to the U.S. for their PhD in computer science stay here in the U.S. afterwards. And so facilitating research relationships and partnerships can be beneficial, as well as China has a very vibrant tech ecosystem. And so getting some of those ideas out of China, the development that China is doing in AI can also benefit U.S. companies.
I guess I'm referring specifically to venture capital deals in sensitive technologies like artificial intelligence. Is there an example where it would be in the interest of the United States to allow an American venture capital firm to take American dollars and invest it in a Chinese AI company?
There might be circumstances. I mean, there might be for applications that don't directly have military human rights applications, things like, say, self-driving cars, where you could see that there's a significant return. I do think we should be looking closely at what is the balance here of the interest and does it disproportionately benefit the U.S. if we're going to permit some of those transactions.
Can you think of any example?
I think self-driving cars could be a place where having those ties between the U.S. and China could be beneficial.
Is there an example of a company that has benefited the U.S.? I guess I'm trying to think, are there concrete examples where it has benefited the U.S. to invest? Because the United States was one of the first countries to actually get to self-driving technology with Waymo and so forth. So are there examples where allowing American venture capital firms to invest in highly sensitive technology verticals in China has benefited the U.S.?
I'm sure there are. Most of the examples that I know are ones that have been on the front page because they were investments in some company that was then committing human rights abuses, which unfortunately there are many.
Okay. So Would you compare, some researchers have compared the development of AGI, general artificial intelligence, as tantamount to the invention of the atomic bomb. Would you think that's a fair analogy?
I mean, any analogy is, kind of fraught, but I do think that the place where we are right now with artificial intelligence is pretty significant. We've seen really tremendous gains in just the last year, and it's unclear how capable AI systems will be even 12 months from now, much less a few years from now. So I would say that in the sense that it is a strategically relevant technology, absolutely.
Okay. And would you have considered that it'd be the right answer for the United States to co-develop a previously highly strategic technology like the Manhattan Project in collaboration with a foreign government like the Soviet Union?
No, certainly not.
So do you think it would be appropriate for the U.S. to essentially restrict co-development in highly strategic technologies between the U.S. and China today, like AGI?
I think it depends on the technology, but certainly for some that have strategic relevance, yes. And so, for example, on AI, the export controls that went into effect on October effectively do this for the most capable AI systems, like large language models like ChatGPT or GPT-4, because they restrict chips that are used to make these most capable systems. Not every use of AI is going to be that significant and that powerful, but for the most capable systems, yes, I don't think we should be enabling that inside China.
So that includes co-development, because right now rules don't prohibit companies from allowing AI centers in China to co-develop advanced AI systems with engineers in the US.
That's right. So the restrictions that are currently in place on the chips from October are very comprehensive on the chip manufacturing side, including restrictions on US persons, and then, of course, on the export of the chips themselves. But there are definitely holes in that arrangement, and it's leaky. There are not restrictions on, for example, Chinese companies using cloud computing services, as well as collaboration on, say, algorithms to design better AI systems. So there are probably other places where, for the most cutting-edge AI systems, additional controls would make sense.
And I guess, and I know we're running up on time, but just to get a little bit more tactical, what I'm referring to is specifically a company using Chinese engineers, pairing those engineers with American engineers to co-develop AGI technologies that are by American companies.
Right, so I'm not aware of any situation where that's occurring today, because the leading frontier labs at Google and OpenAI, for example, are not, to my knowledge, of working with Chinese counterparts on some of these most capable models. But I would not think that's in U.S. strategic interest to do that.
So you would agree that some restrictions might be applicable?
Yes.
Thank you. Commissioner Goodwin.
Thank you, Commissioner Hellberg, and my appreciation to the witnesses. I want to talk a little bit about the Chinese domestic audience here. So in addition to trying to shape international law, especially in emerging fields like space and cyber, and also trying to advance arguments in discrete legal disputes, how much of this construction of legal narratives is designed for Chinese domestic consumption, in the sense that in the arbitration case with the Philippines, when they advance that legal argument, or when they advance arguments regarding Taiwan, is it really designed to win a case before the International Court of Justice, or to shape consensus of international law, or is it designed, as some commentators have suggested, for the Chinese people to say that what our government is doing, what the party is doing, is justified, to create legal sounding arguments, legally plausible arguments to the ears of the Chinese domestic audience that suggest what the party is doing is justified? And I'll open up to the panel. Maybe Dr. Chen, start with you with regard to the conversation on Taiwan.
Sure, thank you. This is a good question, and I think both. China's, in Taiwan's case, I think China is pushing its agenda internationally, and also for the domestic audience as well. Taiwan is a very important issue, we all know, to Chinese, and winning in terms of the public opinion internationally is also a win for Chinese government in the eyes of the domestic audience. I've already talked about small cases in my written testimonies, including China's being able to manipulate the One China principle and then making a lot of leaders in international organizations make wrong statement, inaccurate statements that sort of confuse international law with One China principle. And that also is a good show for a domestic audience. So for example, we see last year, China's white paper issued both in English and Chinese, talking about how One China principle is an international consensus. So I do think there's some traction there.
Anyone else?
I'll just offer, I think the intended audience for a lot of China's international legal practice, and maybe specifically the South China Sea arbitration, which you mentioned, is not so much the domestic audience. I think that it's quite easy for Chinese central leadership to mobilize its domestic public opinion behind its maritime policy. The legal elements that I think are not quite salient. I think that the most salient audience is the region and other states that are calculating whether or not they'll be able to enforce their rights under the law of the sea with respect to the PRC. And they're signaling some scope for that, but drawing some very firm limits around what they define as their sovereign sphere. And that's a point I make in detail in the testimony as well as my book. So I don't think their domestic audience, maybe with the exception of one man sitting at the very center, Xi Jinping, who I think a lot of the policy and rhetoric is performative for. I don't think that there's much of an interest in at least describing China as being a member in good standing of the international legal community. I think that's a relatively minor public relations issue for Beijing. I think they're focused much more on this relevant community of states, and I really want to urge us to think about who they are. To American ears or to Western European ears, I don't think the Chinese arguments resonate, but when you start to look around the developing world, it's quite notable how few states were willing to say anything explicitly critical of China's unwillingness to participate in this arbitration. I think we should not miss that fact, even though it outrages our legalistic sensibility. It's not the case with the majority of countries in the world. Thanks.
Thank you. Dr. Reed.
Yeah, so quickly, I'll say first, the Chinese space program enjoys significant support from the Chinese public. They're extremely proud of China's accomplishments. Chinese astronauts are rock stars in China, just like they are in South Korean astronauts are in South Korea, UAE, and elsewhere. They do a lot of promotion of their space activities to the public. But I think in a similar manner, I think a lot of the legal aspects are more directed at other countries within the multilateral system to kind of engender support. Particularly, China's stances on militarization, weaponization of space is absolutely tailored to speak to the G77 and the global South. Although there's also an element of that is used publicly to characterize American efforts as hegemonic and as pushing American dominance. That certainly goes to the domestic audience as well. On space resources, again, China diplomatically talks about common heritage of mankind, talks about have a global discussion about how to use these resources. So I think that speaks much more towards gaining more diplomatic support than necessarily domestic support.
I'm mindful of time. Do you want me to take a step?
Sure, if you can do it quick.
Okay, so I'll be fast. So I see some of both on digital technologies. Most of China's laws on digital technologies seem really focused at just implementing CCP governance internally, more of the rule by law kind of framework. On the norms and standards of how China's talked about, particularly AI principles or AI for good, those seem to be things that have both a domestic and international audience. So for example, a few years ago, the Ministry of Science and Technology put out a whole list of AI principles, listing sort of ways to use artificial intelligence, like being harmonious with society and advancing a community of common destiny. Some of which are actually reasonable, some of which are notable for how divergent they are from what China's doing internally in terms of using AI for repression. And some of those efforts seem to be very clearly aimed at legitimizing China's uses of AI, both domestically and internationally.
Thank you very much.
Thank you. Commissioner Glass.
Many thanks to you all. I'm going to pass.
Commissioner Friedberg.
Thank you very much. Mr. Cardin, if I could start with you. It seems like there are at least two sets of issues, those involving littoral waters and then those more broadly on a global basis. And closer in, if I understand you correctly, your argument is the United States should place less emphasis on advocating for our military navigation rights and more on essentially helping regional states push back against China's, what you describe as veto jurisdiction. And first of all, is that correct? Yes. Okay. So what would that mean? We're helping, I assume, helping regional states exercise their rights to make use of the resources in these waters. How do we do that from a great distance?
So, as I emphasized in the testimony in the book, as I emphasized in the testimony in the book, China's primarily using its domestic law enforcement, its domestic policy implementation to do things like deny resources to coastal states. And this puts both those littoral states as well as the United States in an uncomfortable position. It's often called gray zone coercion or any number of things. It's a mismatch. And I'd be wary of playing their game, but I think there are ways that we can think about using regional states law enforcement, supported by perhaps United States Coast Guard, capacity support, technical training, maybe some vessels. I don't know what the scope for this is, to enforce their domestic law for their resource rights, not to meet a Chinese fishing vessel with a gray-hulled U.S. Navy vessel, which is a huge problem strategically for the United States, but rather to think about how do we create some competitive edge in this particular dispute over resources.
Okay, so this is really more a matter of power than it is norms.
Well, they're quite closely related, as you'll understand probably far better than anyone in this room. The Chinese theory of the case, such as it is that their power applied purposefully in practice to assert Chinese sovereignty and sovereign rights will become normal in the common sense version of it. It's the normal pattern of practice, and customary international law is effectively that. There's a legalistic patina around it, but it really has to do with power fundamentally.
So, but our assistance to these regional states in resisting has more to do with bolstering their ability to stand up to China's forces, basically.
That's right, and in non-escalatory or less escalatory ways. I think that's the key.
Okay. So as we move outwards from the littoral waters to the global seas, you make this very interesting observation that China's post-colonial branding will be at risk as it goes further outwards. I assume you mean because they're going to be exploiting the waters of other countries, they're going to be maneuvering their naval vessels, they're going to be doing all these things they've complained about with respect to us themselves on a global scale. Is that what you're getting at there?
Yes, I think that China's views on these norms and rules are out of step with its practice in the global sphere, particularly in these areas beyond national jurisdiction. That's what all the high seas fisheries and the deep seabed mining is about. Their interests dictate that they're going to be doing things that are contrary to developing world interests.
Okay. It seems inevitable that that's going to happen because of their needs for fish, minerals, and so on. So what are the implications for the United States and for U.S. strategy? Are there ways in which we can help others resist that, or they're not mutually exclusive? Are there ways in which we can gain some kind of advantage in discursive struggle with the PRC by calling attention to their practices and the contradictions between what they say and what they do?
Well, I think the developing states who are going to be most harmed by China's practices are the ones that are most often in part of China's constituency in a lot of important international organizations and other multilateral settings. And so to the extent that China is undermining that, we need to take advantage of that and be in this discussion about what are the appropriate norms such that, what's the meaning of the common heritage of mankind? It really is quite indeterminate, and there's a lot of scope for that to mean lots of different things in practice, and I think we need to be in that process in a way that we have not been to date.
So this could be an opportunity for us and other advanced industrial democracies to drive wedges between China and some of its worthwhile clients in the development. Okay, thank you.
Thank you, Commissioner Cleveland.
Thank you. Mr. Char, I want to thank you for addressing Commissioner Mann's question and describing the behind-the-scenes efforts at these technical institutions to develop a coherent and solid voting bloc. Commissioner Goodwin, a couple of years ago, chaired a hearing on this very issue, and I think the outcome of that was recognition in the Congress and administration that we should be much more active in backing leaders at these organizations to ensure that we are fully prepared to deal with these Chinese voting blocs. But Mr. Schreier, I'd like to focus on something that Commissioner Hellberg has raised, and I have mixed feelings about it. I mean, I think we can talk about blocking Chinese activities when it comes to AI and suggesting that it's like working on atomic weapons. I think it's also important to point out that when we addressed AI and autonomous vehicles a couple of years ago, we found out that California is allowing Baidu and other Chinese companies to drive on its roads and develop data in a completely unregulated way. And we encouraged an approach that wasn't just state by state in terms of letting China collect data. That went nowhere, noticeably. In your testimony, Mr. Shah, you say, the Chinese-owned social media platform TikTok presents a threat to U.S. national security because of the risks of U.S. persons' data being exfiltrated to China and then TikTok manipulating content on the platform, including censorship, and you provide examples of the censorship. I think that that's the second part is understandable in terms of censorship. I'd like to understand as explicitly as you can offer what the implications are of exfiltrating U.S. persons' data to China, because I think that's something that the Congress continues to labor with in terms of why should it matter.
Okay, thank you very much, Commissioner. I think you can think about two different kinds of data coming off of Chinese apps. So one would be the data that's specific to the use of that app. So in the case of TikTok, what are people watching and what are they liking and what are the content that they're interested in? And then the second one, which has also been a concern with TikTok, is the ability of some of these apps to then gather other information that's on the mobile device. And, as we're all aware, you get these pop-ups on your phone and you hit accept, and oftentimes these apps then are gathering other information, whether it's geolocation data, the use of other apps, contact information, which is far more sensitive than even just which TikTok videos you're watching, and can be very problematic. And
how? I'd really like you to be specific on how, because I think this is central to the debate. And saying that, because my contact list is, I don't have TikTok on my phone, but my contact list is then accessible to TikTok. Okay, I'm 14 years old and I'm shopping on Shein. Why does it matter?
So I think, if a Chinese company and therefore the government is able to access, for example, things like contact lists, geolocation data, that could be used to build information about networks of people. You could use that, for example, in Washington to map connections between people, certainly combining that with other data sources that have come from things like the OPM hack. You could imagine uses going after people for espionage purposes, trying to target them, certainly geolocation data, where people are going, what activities they're doing. You could connect individuals. You could look for ways to exploit individuals, going after them, for blackmail. There's a lot of sort of nefarious things that you could do if you had information that's on people's phones about how people live their lives.
Can't they do it now?
Excuse me?
Can't they do this now without TikTok?
In terms of by what means?
Other platforms.
Well, it'd be a lot harder. I mean, certainly if you have apps that are going to give access to that information on a mobile device, that's creating a door that makes it possible for people to maybe unlock or hack or open that door.
So what I was thinking of is your I think you made comments on cloud computing and servers. I appreciate the fight about TikTok. I just think that there's a bigger concern, and so we can ban it, we can sell it. I think that there is a bigger concern in terms of access to information, and there are two parts to it. What is the nature of that access? How extensive is it? And then the second part of it is, what is the data that is of interest? The shopping habits of 14-year-olds doesn't strike me as a national security risk, but I'm hearing you say that it is somehow. So I think I'd like to develop this for the record and have a more extensive answer, because I think it is, we're operating in this space of generalities of risk and threat, and I just don't feel I fully appreciate it. I'd like to ask a question on space. In your testimony, you say that the Chinese, we are interested in adopting a framework that has to do with claims and extraction. Do you think that the Chinese are more interested in establishing claims or looking at extraction and use of resources? Which is the priority?
That is, as far as we can tell off of all the discussions that have happened, it is on use of resources. So just to recap the law, the Outer Space Treaty, which both U.S. and China are both parties, as well, pretty much every spacefaring country, places a prohibition on national appropriation, i.e. planting a flag, declaring sovereignty over celestial bodies and the moon. There is other language that talks about the ability to extract and use resources. The United States position is that while you cannot plant a flag and claim territory on the moon, individuals, companies who go there can extract regolith, water, whatever they find, and then sell and use that however they may so choose. And the 22 countries that have signed the Articles Accords agree with our interpretation. That's part of that. China, it's interesting because they are planning to do a lot of the same missions that we are that will require extraction and use of resources, including for commercial activities. But they have not come out and stated explicitly that they endorse that definition or that interpretation. They still, in the most of the diplomatic language, are sort of on the side of, well, we need to abide by non-appropriation. We have concerns about the U.S. position. And that's an interesting dichotomy there, because on the one hand, I sense they probably agree with our interpretation and are planning to do that in terms of not ownership, but ability to extract. But they're not quite yet willing to come out and say that explicitly in their statements, in their diplomatic language.
Thank you. At the risk of the patience of the chairs, I think it's interesting. Your testimony is interesting because it says that China is going to do on the moon what China has done in Latin America and elsewhere. But they have an approach when it comes to resources. The moon is just the new venue, the new domain. Thank you.
Thank you, Commissioner Borkoff.
I first want to say thank you to Commissioner Cleveland for setting me up perfectly for what I wanted to ask, and I'm going to extend a little bit. I have watched the progression of individual data, which began with aggregate data, to where we are today with tremendous alarm. And I'm just going to paint you a quick picture of that. In 2003, in 2000, I was very involved in the redistricting in the state of Texas where I live. And as a result, I was invited to go help in another state 3 years later in 2003, where they were considering a redistricting midterm. And during that time, I became aware that the credit card companies were selling information to the political parties, not just aggregate what was being purchased, but by address of people's homes. And they had already done studies about how people were registering, whether they were independent, Democrat, Republican, which things they were buying. And it felt like that was cheating. But, you know, the team I was on knew the other team was doing it. So everybody's doing it. 2003. 2006, I was approached by the second largest credit card company in the United States in my business. And I was doing, in the millions of customers a year. And they said, hey, we can tell you in aggregate what your customers are buying in grocery stores. And from that, we can distill that and tell you what you ought to be selling in your business. And I thought, gee, that's a great thing. It felt a little bit like not fair, but I didn't see it as an aggregate problem. 2013, they came and said, we can tell you what your competitors are doing, and better than that, we can tell you by neighborhood what they're buying. Along about that time, maybe a little before that, but certainly before where we are now, cookies still meant something you ate. But now, cookies to me are part of an evil thing that is invading our lives. You alluded to it a moment ago. You are recommending, Mr. Shar, a federal data privacy law, and I'm in total agreement with that because the information that occurs in 2000, I'm going to take it to 20 and then let you respond. 2020, I acquired and also invested in a small company that was putting Wi-Fi devices in my businesses. And every person who came in with their cell phone that wanted to use my Wi-Fi had to agree to my terms of service, which not only gave me a few things about their information, it told me their MAC address on their phone. It told me all of their contacts on Facebook, their contacts on their phone. It told me all kinds of things. And indeed, somebody walking by my place of business, it snatched their information too. That company later got purchased for a huge amount of money by one of the big social media firms because they had figured out how to collect this data. So there's this insidious collection all the way down to the personal level now. And that can be used in a positive way with AI for medical, can be used in positive ways for many things. Do you have specific things you would like to see done in a federal data privacy law?
I mean, I think one of the most important things is transparency. That one of the situations that you're describing is a market breakdown because there's this information asymmetry. That when you're hitting, accept, even if you read through all the terms of service, you still don't really understand what information you're giving up, how it's going to be used, where it's going. And consumers should have the ability to make intelligent choices about how they use their data, but we need to find ways to increase that transparency to make it simpler. Clearly, the situation with cookies now, where you just get this button you have to click accept on, that doesn't really create transparency. And so, I think getting there is going to be challenging, but I think that's the goal so that consumers can be more informed.
So we're running out of time, and a follow-up on that would be, I'm really asking you, do you favor, I'm not comfortable that transparency is enough. Do you favor some restrictions on online businesses being able to collect specific kinds of data?
There are probably going to have to be some restrictions, or at least on ways that they can do it without consumers being well informed and giving informed consent behind that. Absolutely.
Thank you for that answer.
Thank you. Chairwoman Bartholomew.
Thanks very much, and thank you to all of our witnesses, and forgive me if there's a lot of background noise. My cat is screaming. Dr. Chen, I guess I want to start with you because I think that this whole issue of Taiwan in international organizations is something that Congress has fought a lot about. Successive administrations have tried to do something about. And it certainly seems to me that the decisions that are being made in the institutions are political decisions that they are then trying to justify through legal interpretations. But what more could we be doing to actually increase the ability of Taiwan to participate in these international organizations?
Yes, that's a very good question. I think from Taiwan's perspective, I think consistent push is necessary. So even though Taiwan has been rejected time and time again into these international organizations, I think it's still important to keep up the momentum. And when China exerts political pressures, it often has to rely on some justifications. So that's why it has to launch a legal warfare against Taiwan to convince other members in the international organizations that it is the right thing to do, although it's not. So I think first thing is to correct those false premises, as I discussed in my written testimony. So, for example, the UN General Assembly Resolution 2758 is obviously a huge question, but I think not a lot of attention has been paid to it. And the interpretation of this resolution gives China some leverage to talk to international organizations and say, look, this is just an extension of one China principle, and therefore Taiwan should be banned. But as I said in my testimony, this resolution is only about Chinese representation in the international system. So I think we should begin to talk about Taiwan's representation. It's not about China's representation in the international system. We're talking about Taiwan's representation and the representation of Taiwan's 23 million people. And we're not even talking about Taiwan's sovereignty, because this resolution does not reach this question, does not cover this question at all. So I think there's indeed a need to address the very first beginning premises from which we can then build more consensus and momentum with other democratic countries. Thank you.
You're muted, Carol.
Sorry. Thank you. Thank you, Dr. Chen. A lot of, I guess what I struggle with is, right, activities in technology are outpacing legal systems. And so I'm curious in terms of the surveillance technologies that other countries are buying from China. Are you aware, is anybody aware that there are any violations of laws within the countries where that equipment is being acquired and used?
In most of the cases that I'm aware of, the government is purchasing surveillance technologies that then it can use to establish some kind of mass surveillance system. So, for example, Zimbabwe has bought Chinese cameras and facial recognition technology to put in bus stations and train stations and other public areas to track and monitor their citizens. And rather than that being counter existing laws, in fact, what we often see the governments doing is passing new laws that then give that government some sweeping authorities to collect and surveil its citizens, to gather data and information, to further enable the sort of end goal they're trying to achieve, which is to monitor and track their citizens.
Thank you. I guess it's that issue of passing new laws. When I go back to thinking about what we were talking about in the first panel, right? This idea of China exporting rule by law instead of rule of law, and I'm struggling with seeing that, right? I mean, if what is happening is governments are surveilling and tracking opposition in a lot of these countries, and then implementing laws that is essentially, I guess, a Chinese approach to the law that they are doing. So what's happening is it's happening both from the ground up and institutionally from the top down. That's more an observation than anything else. Anybody have any thoughts about that?
I mean, I think, yes, I think it's a good characterization that what we're seeing is the export of not just the technology and the ways of using it, but also these legal structures of rule by law that other countries, Zimbabwe is a good case. They had a cybersecurity law passed in 2021 that has been criticized by human rights organizations for enabling this kind of surveillance and repression internally.
Thanks. Anybody else have anything?
I'd just add to this idea of what's the potential for export of Chinese rule by law and suggest there's a more general principle underlying it, which is they prize the discretion of sovereign states to determine whether and when and how international law is going to penetrate into their domestic sphere. And that's the key export. It's not the substantive stuff, because that's going to vary a lot over time. I think it'll be very difficult to target. And this is an appealing stance for many countries in the world. China is basically saying is you have the authority as a sovereign to interpret these international legal obligations as you see fit, not as the Americans and the Europeans interpret them in courts in The Hague, et cetera. And I think that is the vehicle for exporting any number of these different types of potentially legally significant types of exports. Thanks.
I think the challenge is really going to be trying to counter that. It's going to be a very difficult thing. Thank you to our witnesses.
Thank you. Commissioner Wessel.
Good afternoon. Yes, good afternoon. And I apologize. I jumped in late to this session, so I don't want to repeat. I hope I don't repeat any questions. And I did hear the questions of Commissioner Mann, Helberg, and Cleveland, who addressed in part what I'd like to raise, which is the issue of standards and how we look at frameworks going forward. And as Congress and policymakers are looking at the question of what the future path of engagement should be with China, there are efforts to try and find areas of cooperation, and that's been true for a while. Healthcare is one, climate is another, supply chain resilience as well. But as I look at many of those issues, it appears that China is seeking advancement or advantage for the CCP rather than advantage for all. And as it relates to the standard setting approach, and we saw this with the ITU and the development of 5G standards, it was clear that the standards were being developed with Chinese leadership and involvement to advantage Huawei. We're now seeing in transportation infrastructure, and our staff did a great paper on lodging and the technology platform being offered free of charge that CCP sponsored that would try and develop common standards and platform for logistics and transportation, where the back end could provide enormous economic and national security intelligence benefits. My question is, do any of our panelists, and start with you, Mr. Chair, see areas of cooperation where it will be for the common good rather than for advantage? Are there guardrails, guide rails, et cetera, that can be put in so we actually can find, sort of the common good approach? Or are we on a path where there are going to be have to be separate protective norms? We're seeing that in the US-EU Trade and Technology Council, et cetera. So are you optimistic or pessimistic about what can be done to find cooperative areas? And should any guardrails be put in place?
Well, thanks so much for that question, Commissioner. I do think there's an important difference between cooperation and engagement. So for on these technical standard setting bodies, for example, we need to be engaging in these bodies, including with Chinese counterparts. That doesn't mean we're necessarily cooperating with them to try to achieve the same standard, particularly if they're engaging in such a way that is trying to bias what should be a technocratic body coming up with the best technical standards, and they're trying to bias it in a way that's going to benefit Chinese companies. Then we shouldn't be cooperating with them. We're going to be cooperating with other partners to push back on what they're trying to do. But we don't want to be disengaged, because we do want to be engaging in that process of setting these standards, working with others. We have certainly a vested interest in what are the standards that others adopt. There was this incident several years ago during the Trump administration when the Commerce Department first put Huawei on the entity list, where very briefly, and the Commerce Department corrected this, a lot of U.S. companies that were engaging in these technical standard setting bodies said, well, we can't go because their interpretation of the entity listing was they couldn't be in the same room with Huawei just even talking with them. And so like that's the kind of thing we want to avoid. That's been corrected, but I think we want to be active and engaged with them. And I don't want to imply that in every instance they're biasing these standard setting bodies. It's not true. The 5G case is a classic case where they very much were. It's not true across the board, but we want to make sure that we are engaged to make sure these standards bodies do stay fair, and we can push back if we begin to see them putting their thumb on the scale in an unhelpful way.
Do you think there is enough expertise and continuity within the U.S. government to be able to pursue our interest there? You mentioned the ITU and the concerns about engagement. I have often seen in terms of the review and engagement, as our Robin indicated in terms of our hearing, that many of our participants came in with sort of a neutral scientific approach, a standards-based approach rather than an advantage-based approach. Is OSTP NIST and OSTP NIST and other entities up to the task in terms of pursuing our interests?
Well, there's a new, my understanding there's a new White House strategy on standards that came out this morning. Not had a chance to read it yet, but I think that's encouraging that there's energy coming out of the White House to do more. I wouldn't suggest that we're there yet. I don't think we should be trying to politicize the standard setting bodies. We want to keep them fair, but it's going to require additional engagement from the U.S. government, additional resources to make that happen. A consistent concern that I've heard from people in industry is that the U.S. government's just not been engaged, and that they want the U.S. government to be helping to support them as they're engaged in these standard setting bodies. So I do think that we're going to have to see NIST and OSTP do more on this type of engagement.
Just as a quick follow-up, any comment on the TTC, the Trade and Technology Council, and your thoughts as to whether that's a productive enterprise and can be a counterweight going forward?
Well, the U.S. has had a number of these sort of multilateral groupings, the TTC, the Quad, which has a sort of tech component. I think they're good. We should double down on them. I don't know that we've seen out of the TTC yet all of the potential for what we could be doing. There are meaningful differences between us and our European allies on a lot of these tech governance issues. But I think it's an important vehicle. We want to stay engaged with our allies in Europe and look for areas of common ground.
Thank you.
Thank you. So we're now going to adjourn for an hour, and we'll be back at 2:05 for our third panel. Thank you to our witnesses for sharing their expertise.
Welcome back. For our third and final panel today, we will address Chinese law and parties in the U.S. court system and how Chinese courts seek to influence U.S. proceedings. Panelists will discuss issues with the U.S. judicial system's treatment of Chinese judicial rulings, the extension of judicial comity to Chinese courts, and CCP attempts to advance liberal values and non-market practices through U.S. judicial proceedings. First, we're glad to welcome Don Clark, David Weaver Research Professor of Law at George Washington University Law School, who will address the U.S. court system's domestic treatment of China's laws. Second, we're glad to welcome Diego Zambrano, Associate Professor of Law at Stanford University, who will address how the party has used the U.S. court system to target dissidents and critics around the world. And our final panelist, Mark Cohen, Asia IP Project Director at the Berkeley Center for Law and Technology, will address how U.S. firms are treated by China's court system and issues relating to anti-suit injunctions in Chinese IP litigation. Thank you again for your testimony. I want to remind everyone to keep their remarks to 7 minutes. And Mr. Clark, we'll begin with you.
Thank you, Commissioner Goodwin. I'm very pleased to have the opportunity to address the Commission today. If you were to read the mainstream news media, you would get a consistent message about China and the Chinese legal system. It's an authoritarian dictatorship. Judges do as they are told if they receive instructions from political superiors, and there's no meaningful judicial independence. But in my experience as an expert witness in U.S. litigation, I found that a surprising number of federal and state judges who presumably read the mainstream media are not getting the memo. I found that their default presumption was that China was, more or less like Canada, and that it was up to the party arguing that it was not to prove their point. And then the judges set the bar for that proof very high. And so this experience prompted me to undertake a systematic study just to try to figure out more accurately what courts were actually doing. And in so doing, I looked at the two main types of cases where U.S. courts have to make some kind of a judgment about the quality of the Chinese legal system. First kind is enforcing a Chinese judgment. So a plaintiff sues a defendant in China, they win, and then they come to the U.S. court with this judgment in hand and say, please enforce the judgment, presumably because the defendant has assets in the U.S. And then the enforcing court has to have some confidence that the Chinese judgment was fairly procured, and so they have to come to some conclusion about how the Chinese court system operates. And then the second type of case involves a judicially created doctrine called forum nonconvenience, which I'm going to call FNC. And in a typical case of this kind, it's a plaintiff suing a defendant in the United States, and the defendant says for various reasons that it would make more sense for this case to be heard in China. Maybe the tort occurred in China, maybe all the witnesses are in China, and under this doctrine, the court may, at its discretion, decide to dismiss to China and tell the plaintiff to go try its luck there. And so, of course, in this case, also, the doctrine requires that the court satisfy itself that the plaintiff has at least some kind of a fighting chance in China or the other, whatever the other jurisdiction may be. And so I collected all the China-related cases I could find regarding judgment enforcement, or FNC, in the whole post-Mao era through mid-2022, and ended up with a data set of about 16 enforcement cases and 60 FNC cases. And I looked at all the underlying filings as well as just the judicial opinions to get a sense of, what kind of information were the courts getting and how are they using this information. So I was looking at the briefs by the attorneys, expert witness statements, if any, and other papers like that. So here are my bottom line findings. So first of all, I found my personal experience to be borne out. American judges do tend to be skeptical of arguments that judicial independence is seriously compromised or that due process is denied, even though parties have raised these official U.S. State Department human rights reports showing the contrary. One judge, for example, this is my favorite example, granted forum nonconvenience dismissal to China while conceding that dismissal would not be appropriate where the courts of that country were, quote, controlled by a dictatorship, thus implicitly making the somewhat startling finding either that China is not a dictatorship or that although it is a dictatorship, its government does not control its courts. Second, in FNC cases, dismissal to China was granted 37% of the time. So this is way more than it should be, given that the applicable doctrine calls for FNC dismissal to be granted only rarely, and you should almost always let the plaintiff sue where they bring suit. But, you know, at least it's less than half. Somewhat more troubling is when you look at it by jurisdiction, federal versus state courts. And I found that state courts granted FNC dismissal, thus implicitly finding that the Chinese court system was an adequate forum. In 6 out of 10 cases, federal courts granted it in only 3 out of 10 cases. Moreover, although the issue with China's adequacy as a forum was not always disputed, when it was disputed, those who argued it was adequate won more often than they lost. In enforcement cases, the picture's a little more mixed. So in terms of pure numbers, a recognition was granted in 6 out of 16 cases, but the numbers themselves are not very illuminating because recognition might be granted or denied for reasons that have nothing to do with the court's assessments about the Chinese legal system. For example, one party doesn't show up. Overall, I guess I would class 7 of the 16 as favorable in theory or in principle to those seeking recognition. 5 are not favorable, 3 are neutral, and 1 is still pending. On the whole, though, I guess I would say in terms of results, the overall picture in the context of judgment enforcement isn't especially alarming at present, but I do have concerns about the future because of the way things are going. So basically, the defendants who lost in these judgment enforcement cases, with only one exception, were defendants who had in some way already really implicitly or in effect voluntarily agreed to jurisdiction by Chinese courts, or else they just simply failed to show up. The problem really that both the FNC and the enforcement cases show is that there's very little genuine inquiry into the nature of the Chinese legal system. The evidence on which courts are making decisions is very thin. And thus, as a substitute for empirical inquiry, what they're doing is relying on precedents without inquiring into what really went on in those precedents. And therefore, one careless mistaken finding by one court can spread quickly throughout the system. And even cases that aren't mistaken tend to get cited by courts and lawyers in support of findings they never made. And in my written testimony, I refer specifically to a Supreme Court case called Sinochem, which is the poster child for a case that's always cited for something it doesn't actually stand for. And it's the effects of these unexamined precedents that concern me the most. So as they build up, in the absence of any countervailing authority, they will encourage the creation of even more precedents in a vicious cycle, and that will have an increasingly pernicious effect. So my conclusion is that any doctrine that requires courts to assess the Chinese legal system for themselves really makes impossible demands on the court system and can't function as intended. It would be an appropriate exercise of congressional or executive power in foreign affairs to provide specific guidance to the courts in these areas. Thank you.
Thank you very much. Professor Zambrano.
Thank you to the Commission for the opportunity to provide views on the influence of the Chinese government in U.S. courts. The main point of my presentation today is to explain that foreign authoritarian governments, including China, have relatively easy access to our courts and, in some instances, have abused that access to go after political dissidents or newspapers in the United States. But there is no need to allow this. As I'll recommend later, Congress can adopt a straightforward fix that would help defendants beat back these political harassment claims. Now, stepping back, I am a scholar of civil procedure and transnational litigation. My research focuses on the legal rules governing cases in U.S. federal courts. So my focus today is on U.S. courts and not foreign policy. Much of my testimony will address the problem of foreign authoritarian governments filing civil cases in U.S. courts. So in basic terms, there is evidence that authoritarian regimes from Russia, Venezuela, Turkey, and China are filing frivolous cases in our courts with the sole goal of imposing legal costs on their targets, be it political dissidents or newspapers. And sometimes they want to force those targets to return to their home countries. So this means that if a political activist or a journalist runs afoul of the Chinese or Russian governments, those regimes are exporting their oppression to our courts. The Chinese government can do this because U.S. procedural rules are permissive. They make it very easy for foreign governments and companies to file claims in our courts. So in my testimony, I want to cover 3 parts. First, I'll explain the legal rules that govern the presence of foreign governments in U.S. courts. Second, I will discuss how China seems to be taking advantage of these rules. And finally, I'll offer a recommendation for actions that the Commission ought to consider, including a congressional statute. So let me begin with 2 basic points about our legal framework. First, the Foreign Sovereign Immunities Act provides that foreign countries enjoy immunity from suit in U.S. courts. That means it's very difficult to file a claim against any foreign government. If you do so, it'll be immediately dismissed. The FSIA, the Foreign Sovereign Immunities Act, does provide a few exceptions, including for claims over commercial activity or terrorism. But those are very narrow. Second, foreign sovereigns enjoy the privilege of access to U.S. courts as plaintiffs, either directly or indirectly through state-owned companies or proxies. There are no barriers. The Chinese government can file any case they want. A state-owned company can do that. The Supreme Court recognized this in a canonical 1867 case involving the rights of the French emperor to file suit in our courts. So the combination of these 2 features, immunity as defendants, but limitless access to court as plaintiffs, creates an asymmetry. Foreign dictators and their proxies can exploit access to our courts to harass any opponents in the United States, but their regimes are in turn immune from lawsuits here. Now, you may wonder whether any of our laws single out foreign authoritarian governments for different treatment. And it turns out that they don't. Both the Foreign Sovereign Immunities Act and the privilege of bringing suit apply equally to democracies and dictatorships. The Supreme Court has implied that courts should not draw distinctions between government types when it comes to immunity and access to courts. Because of this equal treatment principle, courts have long accepted foreign authoritarian governments as litigants. In my study looking at post-1945 cases, I found more than 100 cases in U.S. courts involving more than 20 dictators. You see names like Mao Zedong, Fidel Castro, Augusto Pinochet, Ferdinand Marcos, Saddam Hussein. Sometimes they're defendants, sometimes they're plaintiffs. And more recently, you observe official parties that are proxies of a government, a state-owned company, lower-level officials, or cronies. So focusing specifically on the topic of discussion today, China has been one of the worst offenders. In 2014, a Chinese anti-corruption program announced a legal war against corruption suspects around the world. In this war, Chinese companies filed tort, breach of contract claims that look like any other type of claim against dissidents who have recently fled to the United States. And they do so with the goal of not only imposing costs on them, but also to try to force them to return to China. The use of proxies or state-owned companies conceals the involvement of the Chinese Communist Party, but some Chinese officials have actually acknowledged that this is a strategy. Some of them have admitted in publications that the lawsuits are manufactured and have celebrated when the pressure worked to force a dissident to return to China. This was the case of Peng Shufeng, who claims that he fled China after he refused to testify against enemies of the Chinese Premier Xi Jinping. In response, Chinese officials allegedly harassed him in California, smashed his windows, arrested his family in China, and eventually used a state-owned company to file a civil claim against him in U.S. courts. We've observed this with other political dissidents in the U.S. as well. Now, to be sure, China claims that these defendants violated criminal law in China, and they were not persecuted because they were dissidents or refugees. But that's irrelevant. China is violating basic norms of diplomacy when it uses bogus U.S. civil lawsuits to pressure these defendants, rather than rely on traditional negotiations with the State Department or the Department of Justice. And it is difficult to overstate how difficult it can be for a political dissident to deal with these claims. Legal costs, discovery obligations, court dates, traveling to court, securing an attorney, etc., etc. These are serious impositions. It's also difficult to measure the scale of harm to democracy and political dissidents. We can identify dozens of such claims in U.S. courts, but most cases are going to remain hidden because these governments are using proxies. Moreover, the most important effect is that this can have a chilling effect on other dissidents. Even one successful claim tells any political opponent in the US, you're not out of our reach. We can still get you by filing these claims in US courts. There are currently no straightforward legal tools for defendants to quickly dismiss these claims. And that is why my proposal is that Congress should make it easier for these defendants to file a motion to dismiss, a special motion to dismiss, so that these claims can be dismissed immediately before costly legal proceedings. And the best way to do that is to adopt a statute that subjects the privilege of bringing suit to the robust procedural protections of an anti-SLAPP provision. Happy to talk more about that. Thank you.
Thank you very much. Mr. Cohen.
Thank you very much. Members of the Commission, it's an honor to testify again before you. I congratulate the Commission on choosing an important topic and for convening the experts assembled here today. I begin with a general observation. This moment presents an unparalleled opportunity on intellectual property-related reform to improve national competitiveness because of the fear of China. I hope we can seize it. China's increasing technological competitiveness and its incorporation of IP into industrial planning over the past 2 years have highlighted many of the deepening weaknesses of our own IP system. My hope is that our concerns will drive reforms in our system. These include proposed reforms in such areas as the availability of injunctive relief, the scope of patent-eligible subject matter in emerging technologies, limitations on non-compete agreements to high-tech workers, handling of patent-related anti-suit injunctions from foreign courts, how to handle a flood of low-quality trademarks from China and other countries, the development of more data-driven approaches to competitive threats, and increasing the disclosure of foreign involvement in our IP system, among other reforms. In terms of overall policy, to be effective, we also need a whole-of-government approach. Our trade agency, USTR, must re-engage on IP issues. Science and tech agencies have to begin to work together. We should be looking to DOJ to help better anticipate technological threats to the U.S. on trade secret matters. And I believe the SG, the Solicitor General, can also assist our courts on some of the complex questions involving Chinese law and foreign policy of the type that have already been alluded to by my co-panelists. I will spend the balance of my time addressing specific concerns raised in your questions about anti-suit injunctions, or ASIs. During 2020, China became the leading issuer of ASIs involving patents that read on technical standards, or SEPs, Standards Essential Patents. Recent ASI controversies in China involve SEPs for such technologies as 5G, IoT, Wi-Fi, and other areas. These areas all demand a unified standard to promote innovation and interoperability. During 2020, China briefly emerged as the largest issuer, and China, however, has stopped using ASIs since about 2021. An important caveat to all that is China's system is not transparent, and many SEP cases, particularly those involving foreigners, are not published. In a typical ASI, a Chinese court orders a party appearing before it to cease litigation overseas and threatens to impose a heavy penalty for violation of the order. In some cases, a national court, such as perhaps a U.S. court, will issue an anti-suit injunction, which orders that party to cease pursuing the ASI. One could see the potential for injunction pile-up. There's ASIs, anti-ASIs, anti-ASIs, et cetera. The Chinese courts have also issued ASIs without adequate notice to the affected parties, prompting strong reactions from foreign judges. SEP cases have also been tending to spill over into the developing world, and it would not be surprising if we see more ASI or AASI cases coming from jurisdictions such as Colombia, Brazil, and India. SEP and ASI cases present challenges to our courts, including issues regarding how we handle legal decisions from autocratic legal systems of the types just mentioned. Even if China didn't issue an ASI, however, its fast-track litigation system enables its courts to issue final decisions, set rates, and enjoin an infringer in 9 months, including appeals. China has long used the strategic discretionary advantage that can be applied against foreigners in IP litigation in order to stop parallel litigation in patents and trade secrets. Chinese ASIs accomplish nationalistic tasks. They center global litigation in China, which is an explicit goal of the party in Chinese courts. ASIs stir up nationalism. They weaken the role of U.S. courts. They support China's goals of reducing foreign dependence on technology, of becoming a leader in patent filings, and becoming a leader in standardization efforts. And I recall the hearing, the immediately prior hearing on those topics. They also strengthened China's approach of recognizing SEPs as national assets and not merely private rights, which further erodes the global market-based IP system and strengthens China's role as a global norm setter. Regrettably, ASIs are also a tool that reflects an inherent contradiction in our global IP system. IP rights are territorial, defined by a country, but standards are transnational. In a sense, they exploit some of the lacunae in our global IP regime. The global system of technical standards and its commitments to license patents on fair, reasonable, and non-discriminatory terms, FRAND terms, has enabled China to become the world's largest manufacturer of high-tech goods for products it did not invent. What is not working as well is that Chinese companies should be paying royalties, and they should have been paying them for some time on these products that they did not invent. China's historic share of royalty payments to the U.S. is a fraction of the shares paid by countries in the developed world. If the Chinese government can drive down the royalties its companies pay, or if Chinese companies can drive down the royalties that they pay, their cost of production will be lowered. This could enable more funds for R&D or increase global sales or provide a strategic competitive advantage. As patent-rich companies such as Huawei lose their markets due to export controls in the U.S. and other places, their patent portfolio also becomes an increasingly important, indeed perhaps the sole revenue source. ASIs have become a tool for protecting national champions. One group of academics, I should mention here, Song Rui Lin, the current general counsel of Huawei, in discussing the role of transnational litigation, has said that U.S. patents are diamonds while Chinese patents are cabbages. Who wouldn't prefer suing for diamonds? One group of academics have called China's use of ASIs a ping-pong system of court cases and ASIs. This is not merely ping-pong. It involves key technological assets and the quest for domination of the next generation of standardized technologies. We should let the SEP licensing system be governed by market principles and not let techno-nationalist aspirations lead to control of litigation and rate setting in this key area. Thank you for your time and attention.
Thank you very much. We will go back to alphabetical order and begin with Chairwoman Bartholomew.
Thank you. I have to say this really is wow. This testimony. First, the ignorance of our judges, ignorance or naivete of our judges, Mr. Clark, is really quite astonishing. And as somebody who's had to sit through hours and hours and hours of continuing legal education, do you know if there is any CLE that actually covers what authoritarian or the Chinese legal systems are like?
No, the short answer is no. I don't know if there's any CLE program that covers that. It's maybe something I should suggest to our law school.
I think actually it might be a good idea, and I'm wondering whether we should make taking that course a mandatory course. I am presuming that it is U.S. law firms that are representing these companies in U.S. courts, and that somehow they fall outside of the Foreign Agents Registration Act. Is that correct?
That's a good question. I am not sure what FARA requires if you are a U.S. law firm representing a foreign company. Typically, the Chinese companies involved in these cases, or the Chinese parties involved in these cases, are not. It's not the Chinese government we're talking about, and they may not even be plausibly state-connected. So even if FARA did cover that, in the case of representing the government, I'm not sure it would extend to these cases. And of course, it's not improper for parties to litigation to have legal representation. So I don't want to be understood as saying that these lawyers are doing something unethical by representing Chinese companies in litigation. They are bound to make the best arguments they can, and if there's a bunch of U.S. cases that support their claim, it's their job to cite them. My complaint is more about the judges who are, as you say, it seems quite
bafflingly naive given the actual wealth of information that's out there, in the mainstream media about the Chinese legal system, which is, of course, you might ask for a little more nuance, but it is not basically incorrect. It's basically correct.
And can I ask our other witnesses if they have any thoughts on extending FARA to law firms that are representing Chinese companies?
My recollection may be a little dated, but I think if you're, registered as counsel in a litigation, you don't trigger FARA. But if you started lobbying on behalf of your client before government agencies of various kinds, that would trigger FARA. Nonetheless, I think the use of, when companies act as agents for the Chinese government, or if in fact they're subsidized by the Chinese government, is certainly a concern. It certainly appeared in my recent testimony before the Senate and House, concern about Chinese support for litigation groups.
Mr. Zambrano, can I just ask in terms of who is it who is suing these dissidents that you're talking about?
These are typically state-owned companies. It is not the Chinese government itself. It is not a government agency or instrumentality. It is a company that the Chinese government has influence or some ownership stake in.
Or control of, right? I mean, we've talked a fair amount over the years about how independent these state-owned enterprises are. Again, I recognize that U.S. law firms do what they do, and they have a right, everybody has a right to counsel. I just wonder if there's something we can do about the exploitation of what they're doing, and one of the first steps of that might be transparency. Thank you.
Thank you. Commissioner Borkoff.
Thank you very much. Listening to the three of you, in my mind, what I categorize is there's a problem with our companies being able to sue for loss of IP. And then there's a problem with when they do sue, the judges just throw it back to China. And then lastly, we've given an open door, this incredible opportunity for the Chinese government to punish people that don't speak highly of them or do something else. So there are two different problems that both have to do with the fact that our courts don't work well with the Chinese system. So I want to start with you. First, I want to say thank you to Mr. Cohen for the last time he was here, enlightening me. We aren't going to spend any time on it today, but I'm still amazed that there is such a thing as an anonymous patent, which apparently China has. It just blows my mind. Mr. Zambrano, I didn't know about anti-SLAPP. Everything I've learned about the law, and I know a fair amount, has been from defending myself against civil suits in my business. I could probably write a book and call it Mr. Defendant. It's not fun. It's expensive. The common thread through everything you say is that the judicial system can be used as a weapon, and I have experienced that and have utilized it. It's a legal thing that happens in America. It's not pleasant. All lawsuits are expensive, very, very expensive. They should never be used to silence people who have a right to speak, and they should never be used if one side has a tremendous advantage over the other. So I would like you to expound a little bit on how you envision, I don't know enough about, I had to look it up and read a little, strategic lawsuits against public participation. So I understand they prevent speech and assembly and other things. How would that work federally? I don't understand how somebody would prove that that was the reason for the lawsuit. You know, state-owned enterprise sues you, so you go in and say, oh, they're only suing me because I said I don't like China. How do you prove something like that?
Thank you. So the good thing is that there's a lot of experience with SLAPP lawsuits at the state level. So in the early 1990s, a lot of scholars and observers noticed that there was a proliferation of lawsuits by companies sometimes against regular citizens for speaking out against a construction project. And the concern was that these defamation lawsuits often were only for purposes of harassment and for imposing costs. A series of states, California, Texas, Washington, adopted what they called anti-SLAPP suits. And as you mentioned, strategic lawsuits against public participation. And the goal was that, well, we're not going to stop you from suing. That would be very difficult to do. You can still file such a suit, but we're going to let the defendant file a special motion to dismiss, telling the judge, I am being sued only because I exercised my First Amendment rights at a public meeting, right? And this lawsuit is frivolous and being imposed on me only to harass me, all right? So you do have to meet an initial threshold. Now, there are more than 20 of these laws around the country. They're not all the same. But often what they do is say the defendant files a special motion to dismiss, and they show in that motion to dismiss that they spoke at a public meeting, for example, and that then the lawsuit was filed against them, and that there is no sufficient evidence that the lawsuit is bogus in a certain sense. If the judge thinks that initial threshold is satisfied, then the burden shifts to the plaintiff to show that actually they have a high likelihood of prevailing on the merits, that they're filing the suit for proper purposes. And what anti-SLAPP statutes do is they impose a quick 60-day limit so that this whole process does not extend, does not impose legal costs. These decisions can also be immediately appealed, right? So they can also end up imposing punitive damages against the plaintiff for filing such a claim. So it's all designed to simplify, speed up the process, and allow the defendant to quickly dismiss that claim.
Thanks for that answer. And I didn't understand at all that there was a loser pay aspect to it, which I really, really like. Thank you.
Commissioner Cleveland.
Thank you. I'm not a lawyer, so these questions may be oversimplified, but Mr. Cohen, I think we will all appreciate going forward the diamonds and cabbages concept. I'd like to understand, if I heard you right, you said China is the largest manufacturer of products they don't invent and upon which they don't pay royalties. Could you address how we might better enforce that, the last part of that, in terms of paying royalties? And then you also mentioned that you thought the Solicitor General had a role in assisting courts. Could you elaborate on that, please?
Let me come to the second question first, because it kind of sheds light on the first as well. There was a case in the Eastern District of Texas Judge Gilstrap handled. It involved an anti-suit injunction from Wuhan. And Judge Gilstrap, rightly so, issued a what he called an anti-interference order. He said that U.S. citizens, U.S. companies have a constitutional right to litigate U.S. patent infringement claims before a U.S. judge in the United States, and he wasn't going to take no from a Wuhan court. What he did not do was address the residual, very big issue, is that the Wuhan court now had jurisdiction of the whole world except the United States. So that, to me, was a huge error. And I think it has something to say about judicial conservatism, about not interfering in other courts' jurisdictions, something along the lines I think that Don and Diego have spoken to. The way around that, the only way around that I could think of, would be if the Solicitor General stepped in or some other authority and said, well, no, that's not really the way we view things. We think it's equally wrong for a Chinese court to be tasked with global rate setting. And if you wanted to go a step further, even the U.S. could do that, or the whole, the structure of an anti-interference order could be of a broader nature. The fact is that China has this goal of not only resolving disputes, getting to your second question, but also setting global rates. In a case called Conversant, I think against Huawei, the rate set by a German court was 18.3 times higher than the Chinese rate. Some foreign courts have said, well, you know, the Chinese rate is maybe half of what a UK rate might be for setting a royalty. I don't know how we come up with these numbers, other than it seems like a tremendous act of judicial magnanimity to say that Chinese courts and Chinese companies who dominate the landscape, producing 80 to 90% of the cell phones, are somehow entitled, because they have such a dominant monopolistic role in setting prices, they're somehow entitled to a lower price. So what can we do about this? Well, first of all, we need better information. We should not be so timid, I think, about filing WTO disputes. I know there was a discussion in the last session about WTO disputes. I think WTO disputes, even with the dispute settlement body paralyzed, still have a very beneficial function of disclosing a matter to the global trading community and at least making the U.S. or other players look like a rational actor. And in the case of the EU case that was brought against ASIs, it appears to have had an effect, we can't say this for certain, of stopping China's ASI practice while the case was pending. So I think there are international remedies. There's also addressing the problem of Chinese subsidization of patents and a participation in standards bodies that can be addressed through, for example, energizing NIST a good deal more, or simply getting our agencies to work together. When NIST, PTO, and DOJ came out with a proposed a policy on standards essential patents, the word China did not appear in that policy. The word international did not appear in that policy. The failure to consider the international consequences of actions that occur domestically but may principally affect China or our trading partners or even allies is really shocking, and it really needs to be, our agencies need to do better in addressing these things.
All right, Commissioner Friedberg.
Thank you very much. I am also not a lawyer, and I want to thank our panelists for such clear papers and explaining to non-lawyers what some of these rather complex issues are. Professor Zambrano, I wanted to start with you. Your discussion of the use of U.S. courts by Chinese litigants seems to focus exclusively on cases in which the plaintiffs in those cases are also Chinese nationals. Is that correct?
Both the plaintiff and the defendant in those cases, yes, they're Chinese nationals. That's right.
Okay. Are you familiar with instances in which the targets of these suits have been American citizens? So I'm familiar with one such case where it was obvious that a Chinese entity, I believe it was a state-owned enterprise, was suing, I forget what the allegation was, it might have been slander or something like that, against a U.S.-based analyst of Chinese policy. And it was clearly an attempt to harass this person and impose legal fees on them and so on. How widespread is that practice? Do you know?
I am familiar with many cases where other authoritarian governments have sued U.S. newspapers. So for instance, Venezuela's vice president sued the Wall Street Journal, allegations of defamation because they linked him to narco trafficking. Russian oligarchs have sued BuzzFeed. And I am aware of lawsuits involving U.S. citizens. Now, specifically with regards to China, I don't think the 6 or so cases that I specifically looked at, the defendant was typically a Chinese national as well. I don't know if they were dual citizens potentially, but I'm not sure.
Okay. Because it seems like this is one area where, and I know, for example, after this case, the word sort of went around the China watching community in the United States, and people, particularly those who are working on Chinese influence operations, became very anxious about the possibility that things that they wrote might expose them to this kind of suit. I just don't know whether that's become more widespread.
I'm sure it is. The difficulty is that some of these cases will remain hidden from us. We'll never know, in a sense, especially if the parties settled quickly, right? So this is one of the main difficulties with these kinds of cases. By the way, I should also mention Turkey was involved in one of these political lawsuits as well against a cleric who lives in Pennsylvania who is a U.S. citizen. But I think that this is widespread. I am sure it's happening, and my guess would be that it does involve U.S. citizens on the defendant side as well.
Okay, thank you. Professor Clark, your proposal for taking the determination about the status or capacity of a foreign legal system out of the hands of courts and putting it in the hands of the executive branch seems eminently sensible. But what would be the basis for a judgment on which category a certain country should be put into? How would you expect that the assessment would be made that this country has a legal system that's compatible with ours or meets up to our standards, and this country doesn't have such a system?
Yeah, that's hard to answer specifically, because it really is a question of kind of judgment, ultimately, by experts in the system of that country, trying to look at the whole system and come to some holistic view about whether, on the whole, it is fair for U.S. courts to be enforcing judgments from that system or to be dismissing cases to that system. Surely one thing one would want to look at would be, is the judiciary actually independent, in some meaningful sense? Is there political interference that occurs in some, unpredictable way? How opaque is the system? One thing that really struck me in looking at these cases was that the sorts of demands that judges were making on parties arguing that China was not fair would advantage opaque legal systems, because they wanted evidence. And if that's the case, then of course North Korea scores very high if you have to come up with evidence of unfairness or political influence in the legal system. So really my thought was that the executive branch, perhaps the State Department, is really the best placed to come up with sort of an authoritative statement saying, and specifically addressing, the issues that courts are concerned with in judgment enforcement and forum nonconvenience cases, and to say, it is our judgment, it is our view, the official view of the executive branch, that for example, China or Venezuela or some other country does not constitute an adequate forum for the hearing of U.S. cases, or does not regularly grant due process. And even if that is not, I think that would be very hard to make mandatory on state courts. But the way litigation goes, I think if an attorney comes up with that statement and says, here is the executive branch officially making this finding, it's going to be very hard for a judge to say, well, I think I know better. And so I'm thinking the way litigation would go, that even kind of an advisory opinion would be useful.
Thank you very much.
Commissioner Glass.
Yes, thank you.
Then it's my turn. Professor Zambrano, I want to talk a little bit about these state anti-SLAPP laws that you referenced in your testimony, and how that actually ties into your recommendation for the need of a federal anti-SLAPP bill. It's my understanding that there is a split among federal circuit courts with regard to whether some of these state anti-SLAPP statutes can apply to proceedings brought in federal court. Talk a little bit about that to set up what that means and why would it be important to have federal legislation.
This is a very tricky area of law that I teach my first-year students every year. It's called the Erie Doctrine. So typically, the federal courts have their own procedures, the federal rules of civil procedure. The state courts also have their own procedural rules. So what happens when you have a state law claim, like a defamation claim, breach of contract, tort, but in federal court? The federal court then has to decide what kind of procedure to apply, and there's a complicated test. Generally, if the question is procedural, the federal court will apply federal procedural law. If it's substantive, it'll apply state substantive law. The difficult thing is whether an anti-SLAPP statute is procedural or substantive. And there's a split among the circuit courts on this question. Some courts have found that an anti-SLAPP statute is inextricably tied to the substantive claim. So you have to apply it in federal court because it's substantive. While other courts have said, no, this is procedural, and the federal rules of civil procedure are incompatible with a state anti-SLAPP statute. And therefore, we cannot apply California's or Texas or Washington's state anti-SLAPP statute. So what is needed here is a federal anti-SLAPP provision so that federal courts will consistently apply it. Moreover, I really do think that in this context, judges, courts generally are uncomfortable with making judgments against foreign countries. And I think we touched a little bit on this with my co-panelists. I don't think that judges are ignorant or naive. I think they're uncomfortable with getting involved in cases that affect foreign policy. And what you need is Congress to make a clear statement. We want you to get involved in this. We are authorizing you to get involved in this. And the only way to do that would be a clear, simple, congressional, federal anti-SLAPP provision.
Well, let's talk about that provision a little bit. You touched on some other aspects of how you would envision the legislation working. It seems to me a critical aspect would be how you determine who is a proxy for a foreign government. So how would that work? Who bears the burden of proof on establishing that, and what is the framework for rendering that sort of determination on the front end?
Yeah, I do think that there are a couple of tricky aspects to what this statute would have to do. One, what kind of political lawsuits are covered, right? When the defendant, say a Chinese dissident living in the United States, gets a lawsuit and they file this special motion to dismiss and they say, I'm being harassed. This is not a real lawsuit, it's a frivolous lawsuit. What would the statute cover? I'll talk about that and then move on to the proxies. I think here courts and Congress can draw on analogous circumstances. For instance, in the refugee context, when a refugee is claiming that they are victims of political persecution, they have to show that one central reason for why a foreign country went after them is political. So we do that quite often in other contexts, and we should encourage the courts to draw on that experience. It is possible. For instance, if there is a easy, straightforward connection between publication in a foreign country or an event, a political protest, and then a foreign country prosecuting someone, quickly followed by a civil lawsuit in the US, you can see how that would meet an initial threshold that this is a political lawsuit. Now, second, and to your question, what about proxies? A lot of these cases, again, are not filed in the name of the actual foreign country. It's a state-owned company. Sometimes it's regular citizens. That's the way Turkey did it. How did we know that it was Turkey? Turkey was paying for the law firm representing the plaintiffs. And the lawyers were very clear that this was a political lawsuit. They just told us. So how about more difficult cases when they don't tell us? Well, there are analogous inquiries that courts conduct when they pierce the veil of corporate structures, trying to determine what company is really involved in this case. If there are multiple shells, courts have developed tests to figure out who the real party in interest is. Moreover, you can scrutinize who is in control of the lawsuit, who is paying the lawyers. You can require disclosures. We talked about this earlier in the first question. If you have disclosures of who's paying the lawyers, that would help a lot. And so I think that there are a lot of other contexts where Congress and the courts could draw guidance to do this. I think it would be very straightforward. And the fact that anti-SLAPP statutes are successfully being used in more than 20 states tells us that.
Thank you. Commissioner Helberg.
I'll pass, thank you.
All right. Commissioner Mann.
Mr. Clark, you said in passing on your testimony that it would be useful to have congressional guidance. I didn't know if you were talking about a law. What would the guidance be? Would it take, what would you recommend? Is there a law that should be passed for FNO and enforcement of judgment claims?
Yeah, so my I guess expertise is more in suggesting what should be done than in suggesting how to do it, because that involves, a lot of complex constitutional questions about, what should be the division of labor in Congress and the executive, and then between the federal government and the states. So the thing that, so I'm not sure that Congress could do much by way of a law. That's my short answer, but it's not an authoritative answer because I could be wrong. My I tend to gravitate more towards the idea of executive branch solutions. And again, I think sort of authoritative statements upon the specific issues that courts are facing by an executive branch agency would do two things. One, it would be extremely difficult for a court to hold to the contrary. And second, it would, eliminate these concerns that courts often have, as Professor Zambrano has stated, about kind of infringing on the foreign affairs power of the executive and of Congress. They're very concerned that if we say something, disrespectful about the Chinese government, this is going to cause a diplomatic crisis, even though this has, never happened, as Professor Zambrano points out in his testimony. So it's kind of an unfounded fear, but it's nevertheless there. I think in terms of, rules, sort of mandatory rules that could be passed, again, one thing I suggest in my testimony is just abolishing forum nonconvenience dismissal, at least to foreign jurisdictions. And that might be constitutionally within, Congress's power, under its, power to regulate the economy, but that's not a subject that I'm an expert in.
Thanks. Mr. Zambrano, when you talk about harassment of dissidents, of course, we all form in our mind the image of some Tibetan or Uyghur protester in the United States. But what if it's someone who's very wealthy and high-powered? What do we do with a messy case like Guo Wengui, where the guy comes out, claims he's a dissident, funds other dissidents, and then it appears that maybe he's an agent of the government that he claims is harassing him. I don't know what the law can do on cases like that, and what happens when that ends up in court.
I think in those cases, clearly the Chinese government should be negotiating with the State Department and Department of Justice. But what happens if one of these sophisticated defendants, who may actually be really a criminal in that country, takes advantage of the statute? I'm not too worried about having the statute be over-inclusive, because all that it is doing is shifting the burden to the plaintiff. Ultimately, this is not telling you can't bring these lawsuits. All that it is doing is allowing the defendant to quickly shift the burden if they show an initial threshold that they're a political victim. Then the plaintiff has to come forward with some evidence. And if they have evidence that this is a real case, that they have a substantial likelihood of winning on the merits, the case will go forward. No problem. But I'm sure that many cases, if the statute were enacted, will involve sophisticated defendants who have the lawyers to take advantage of this kind of statute. But I think I'm very comfortable with this being over-inclusive, because the plaintiff can still go forward with their claim.
Thanks. Thank you very much.
Commissioner Price.
Thank you, and thank you all for your excellent testimonies. I'm in the situation where most of my questions have already been asked, but Mr. Cohen, there's one more. You were talking in terms of a task force in your recommendation. Can you talk a bit about ideas on what the responses that a task force would be tasked to put together would look like?
Thank you very much. This is a big topic and an extremely important question, but to give you one sense of the problem is you have a asymmetry between agencies in the U.S. government that have resources, whether human or physical resources, to deal with some of the challenges from China and technology, and other agencies that have more power but fewer resources. The classic example is a comparison of USTR and the USPTO on IP-related trade issues, where you have, when I led a team of 20 people in 4 cities, there may be one person in USTR who deals with China IP issues, or maybe 2, one in the China team and one in the IP team. How do you drive informed policy when you have this disequilibrium? And the only way to do it is if folks are encouraged to cooperate across agencies and you minimize redundancy. If you don't minimize redundancy, you're condemned to superficiality, which is basically what we have in a large part of our China trade policies. In IP, it's not only USPTO and it's not only USTR, it's DOJ, it's the Copyright Office, it's ITA, and several other agencies that have different folks sitting in on IP and IP committees. So you have to really, absent a massive reorganization, which is probably too large an undertaking, you have to create incentives for people to collaborate, and you have to maximize the available resources. In the example of PTO, you have the largest, I think it's the second largest database in the United States on technology and science issues. We're all struggling here about where to impose export controls, how to deal with investments, outbound or inbound involving China, where the emerging technological threats are. We need to re-engage on forward-oriented technology analyses, which was actually something pioneered here in Congress under the Office of Technology Assessment, which regrettably was disbanded. But these were analyses that would aggregate scientific publications, patent data, talent flows, et cetera, to try to anticipate where the next technological challenges are. China does these, Taiwan does these, Korea does them, Japan does them. Some of them even have obtained patents in novel ways of analyzing technological threats. We don't do them at all, at least in the government, as far as I know. So what does a task force does is cleans up a mess and creates structures where agencies can work together and are incentivized to do so.
Thank you. That's all I have.
Commissioner Shriver.
Thank you, Mr. Chair. Thank you to our witnesses. A really fascinating and troubling discussion. Mr. Zambrano, you indicated that there's a lot of underreporting because cases can be settled, et cetera. I would submit that even short of a case that gets to the point where it needs to be settled, a cease and desist letter can also resort in organizations and individuals having to expend resources for the potential defense, which I'm familiar with a research organization that received such a letter, and in fact, my organization had to hire somebody just to sort through the potential vulnerability of a cease and desist letter. So I think it's a pretty big problem, but which leads to my question, are you familiar, you've done excellent research in this area, but are you familiar with any inventory work that's as comprehensive as could be in terms of collecting all this, the actual cases that may have been settled, other instances of legal harassment? Does somebody have the comprehensive inventory of this?
Not that I'm aware. I tried to do my best in finding these claims, but the only way to find them for a researcher like me is to look at when the defendant claims in a motion to dismiss or an answer that they're being persecuted and that this is a frivolous lawsuit. If they haven't claimed that, I can't tell.
Sure.
The State Department, FBI, were quoted in the Wall Street Journal story involving this declaration from an organization in China that there was a legal war against corruption suspects. So they might have more information about these claims. It looks like they were contacted in some of these cases, so I think they could have more information. But otherwise, no, there is no inventory of these claims.
Well, that's exactly what I was wondering, if Congress were to direct some part of the executive branch to either themselves or contract with a capable research team to develop that inventory. Would that be a useful thing to have in your opinion?
Absolutely. I think that would be great. And more generally, going back to some of the questions before about how we figure out who is a proxy, guidance from the State Department, guidance from the executive would help the courts in these cases. And the executive does file amicus briefs. And as my co-panelists discussed earlier, the State Department has developed a lot of tools to evaluate foreign governments' authoritarian nature and involvement in our courts.
Yeah, and actually that led me to, I was going to ask Mr. Clark, I mean, it seems to me your instinct of looking toward the State Department is a good one. It strikes me that in our annual human rights report, normally there's a section that talks about rule of law, quality of the judiciary, et cetera. Would you favor in the annual human rights report where we talk about rule of law an explicit recommendation on FNC or some of these other issues you raised? Yeah. I mean, we do travel advisory. We do a lot of things out of the State Department to protect American citizens, like travel advisory, healthcare, So why not actually have the State Department put in this annual report that they're already doing an explicit assessment?
Right. I'm glad you asked that question because that comes up a lot. And I would not recommend that anything like this be included in the human rights report, that it be in a separate one, because what happens, and I see this all the time in these cases, is that when a party says, look, the State Department in this human rights report said, China doesn't grant due process, yada, yada, yada. The other party says, well, that's just on these political cases. That has nothing to, this is a civil case. This involves breach of contract, in a manufacturing situation. And so that has nothing to do with this. Chinese courts, we concede that there's problems in these political cases involving dissidents, but this is a civil case, totally different. And if the court wants to dismiss the case, then they can just say, right, they can buy that argument, or even, even if they're not predisposed to dismiss the case, they will buy that argument. And I have just seen that argument made and accepted in so many cases that I think it should be in a separate, document that says we're not talking about human rights in particular. This is a general assessment of the Chinese legal system, specifically for courts that are looking at issues of FNC dismissal or that are looking at enforcement of judgment cases. I don't want to make that argument available to parties to say, well, this is just the political cases.
Okay. That makes sense, but the Congress could direct the State Department to produce such a report.
I think they could. They directed it to produce the human rights report, so they could ask the State Department to produce it in some other, for some other purpose as well.
Thank you.
Thank you. Commissioner Wessel.
Thank you to all our witnesses, to our co-chairs for setting this up and initiating this hearing, and Mr. Clark, thank you for returning. Mr. Cohn, Mark, I think this is your third appearance before us over the years, and your scholarship and advice has always been helpful. And to all of our witnesses, thank you for the thoroughness of your work. I have questions for Mr. Zambrano and Mr. Cohn. And Mr. Zambrano, following up on our chairman's question regarding the anti-SLAPP and federal statute. And there have been efforts, I think, most recently by Chairman Raskin to have a federal anti-SLAPP statute. Isn't there still the problem of dismissal without prejudice that allows many of these parties, multiple bites at the apple, and that allows for a foreign plaintiff here, let us say a Chinese associated entity, to, sap the economic resources of a defendant here in the U.S.?
Yeah, absolutely. If a claim were dismissed without prejudice, then the plaintiff would be allowed to come back and refile the claim, and that would be a problem. So I think it's important to look at how punitive the anti-SLAPP dismissal would be. And as we mentioned earlier, if it involves not only paying legal costs, but beyond that, that would be enough punishment, I would think, to even deter some of these claims. But yes, that's part of a provision that would need to be examined closely. What kind of legal costs or more punitive damages you impose on these plaintiffs, if there is a finding by the court that this was a SLAPP lawsuit.
Right. In California, they allow, I think there are repeated, I've seen cases where there are repeated dismissals without prejudice, again, that just rack up the bills, and often a wealthy plaintiff can, again, undermine the resources and get away with, I don't want to say murder, but significant harm. Are you aware of that? And are there provisions in any of the, I think you mentioned 20 states that have provisions you think we should look at as the Congress potentially examines legislation?
Yeah, so there are broader and narrower anti-SLAPP statutes. California is an example of a broad one, not only in that it can include attorney's fees and legal costs, but also in the amount of lawsuits that are covered by the anti-SLAPP statute. Arizona has a narrower version of an anti-SLAPP statute that's really concerned only with First Amendment style exercises of speech and retaliatory lawsuits coming out of that. On the cost, I'm happy to look more at that. Actually, I don't have a complete understanding of what these 20-plus statutes do with regard to costs, and whether some of them exceed, again, attorney's fees and legal costs, and go beyond that. And I would be happy to look at that question.
Okay, thank you. That'd be helpful. And to sort of take a jump off of Chairman Bartholomew's question regarding FARA, but I'll apply it to the question you said where there was the ability to pierce the veil and find out that Turkey was paying the costs. What kind of discovery, is discovery adequate here? Or if there was a federal anti-SLAPP statute, are there some specific provisions we may need to adopt?
Yeah, I love that question because I've written a lot about discovery. So there are going to be a lot of easy cases, and I should have mentioned that earlier. But look, if you're a state-owned company, you should be covered, right? Any kind of company where a foreign government has a stake should be covered, right? So they will fall under the umbrella of this anti-SLAPP statute. If you are in any list, either sanctioned, for example, Russian oligarchs, we have long lists of individuals who are linked to the Russian government. If you are in any such list, you are covered. That's an easy case. If you're in any list produced by the State Department, FBI, that's covered, right? So the trickier cases are going to be when a regular citizen was drafted by a foreign government to file this lawsuit. And then the question is, who is paying for that? But here's another angle. Who is the beneficiary of this lawsuit?
Right.
If this lawsuit goes forward and we think the foreign government is the main beneficiary and not this plaintiff, that's a reason to cover that lawsuit as well under the anti-SLAPP statute. And yes, you're right. In that inquiry, there may need to be some court power to look into these questions, including something like jurisdictional discovery. And I should say, courts do have the power at the jurisdictional stage to order discovery. So this would be analogous to that.
That'd be great. I see my time's up. Let me, Mark, if for the record, you could give us answer to two issues. One, have you seen any specific targeting of technologies within lawsuits, filings, et cetera, that would give us somewhat of a roadmap of Chinese priorities, AI, quantum, whatever it might be, number one. And number two, what is the current state of affairs with regard to foreign persons being able to have access to the PTO database that can provide enormous opportunity to visibility into U.S. patents, understanding there's a lot of trade secrets and other things, et cetera. So if that could be provided for the record, it'd be very helpful.
And Mr. Cohen, we're actually doing pretty well on time if you would want to answer now.
Yeah, I can answer them briefly. As far as I know this was a discussion of a few years ago about China accessing the USPTO database.
Right.
What they wanted at that time was the CDs or the physical media, since they could have gotten online and had the same access like anybody else has from anywhere else in the world. And I think the data was provided at that time, so they had easier access. The problem is patents are published. I know that CNKI is talking about not releasing its patent data, and I've spoken to a former director of the USPTO who thought that somehow violated TRIPS or other obligations. I suspect it would, but it's fundamental to the patent system that it's published. What shouldn't be published, and it's not publicly available, are trade secrets, other confidential information, notes perhaps of the examiner and the like. But in general, this stuff is publicly available. What the PTO has that is not publicly accessible, I don't think it's even accessible to other agencies, are certain tools to assess whether there is prior art that could be used to invalidate a patent. And this involves searching through scientific literature, patents from other countries and the like. And that's the kind of data that I think could be extraordinarily useful to the interagency community in drafting up a better export control regime, CFIUS regime, and coming up with good technology policies. And that's what I was partially referring to. In terms of targeting technologies, I think what we're primarily looking at, and I'm saying this kind of instinctively, not based on any research, but that I think most of the litigation, at least the high-profile litigation, is in consumer technology where the money is. People are bringing cases largely to recover or achieve some of that diamond promise of the U.S. patent system. So you're looking at 5G technologies, IoT. The automobile sector has also become quite hot of late, and not anything much beyond that, really. And I think you've seen also Chinese companies that have been joining patent pools that are being asserted against big U.S. tech companies, along with other countries. Some people find that offensive. I don't necessarily find it offensive, but I do think there is a problem with low-quality Chinese patent assertions, and also the way China will sometimes ramp up on declaring patents as standards essential. Typically, a U.S. company will declare a patent as standards essential for 2 to 3 technical standards. China will do it for 6 or 7. Part of that is responsive to subsidies. That also makes China look like it's a bigger standards power than it otherwise would be. You have the same problem with patent subsidies. So I think this is largely commercial technology that we're looking at, not areas that necessarily represent a distinct or new threat.
Great, thank you.
Vice Chairman Wong.
Professor Clark, you've collected cases, examples going back to the post-Mao era. The post-Mao era is roughly 47 years, almost 50 years, and you indicate you found 60 cases of forum nonconvenience and 16 enforcement cases. Are you comfortable that's basically the universe of cases, or is this much larger, you just haven't been able to find it? Because that's a long time for so few cases.
Right, so the post-Mao era, I'm basically talking about the era of economic reform from 1979 on. There were not a lot of cases until basically the 2000s. So I'm not sure if there were, do I dare say none, but basically those cases are every case I could find. And I'm pretty confident that I found them. So they're not supposed to be a representative sample. That's supposed to be the universe of all cases.
But it's more like 60 cases of FNC in roughly more of like a 25-year period, not a almost 50-year period.
Yeah, that's correct. So that's, in fact, less than more like over 20 years, perhaps.
Okay. I don't know if you were here for the first panel, but one of the our witnesses, Dan Harris, no friend of the Chinese legal system or no fan of it, he had something he called the 90-10 rule. 90% of cases, particularly in the commercial area, generally adjudicated roughly fairly in China, 10% where it's strategic industries or politically sensitive, it's not. If we're in a situation, I'm a court, and I'm looking and I'm absorbing and taking as fact that 90-10 rule, don't you think that's pretty reasonable for them, therefore, in a kind of an adequacy inquiry under FNC to be deferential? How would you respond to that?
Sure. So my response to that is that you can't, even if that's true as a statistical measure, you cannot tell in the context of any particular case whether it's going to be true. So I don't agree with the distinction that many, people I respect make, which is that there's sort of political cases on the one hand, and then there's, which are subject to interference, and then there's non-political cases on the other hand, because you just cannot tell. So for example, there's let's suppose we have a case of, workplace injury. This is an actual case, workplace injury, somebody's injured in a factory accident, in some small town somewhere, and the factory owner, is on the local People's Congress. That case, and this, as I say, is an actual case, that case never goes anywhere because it becomes a political case. So to me, the question is, do the channels exist in any particular case for interference should some suitably senior or powerful person want to interfere? And the answer is yes. All those channels always exist. So we just cannot tell beforehand. And therefore, when a party comes to an American court and says this case is going to be subject to this type of interference, or in an enforcement case, this case has been subject to that type of interference, for the court to say, well, that's 90% probably wrong because it's a civil case or something like that, or to say it's 100% not going to happen because it's a civil case. That to me is not a correct assessment of the Chinese legal system, and the very opacity of the system makes it impossible for the court to figure out just how, whether it did actually happen in a case that has already occurred. So that's my answer.
Just a clarification point. You mentioned your testimony, essentially what you cite as bad precedent. One bad decision has a systemic effect given our, presidential common law system under these rules. Are you citing decisions on the legal inquiry that we're not supposed, or courts say they're not supposed to inquire about the nature of a government? So basically, is it a precedent on the question in the inquiry under an FNC decision? Or are you citing precedent where they say the Chinese government or the Chinese court systems generally fair, which it seems more fact-based to me?
Right. So, well, there's both kinds. I mean, there are cases which have produced quotes that get produced and reproduced throughout the system, where it says, U.S. courts should not cast aspersions on foreign legal systems, which are, those are just misstatements. The U.S. courts have to do that, for example, if they're making a judgment about whether a person is likely to be tortured if they go back to China. The Torture Convention requires you to make that, possibly a very insulting, judgment about the Chinese legal system. But there are, I have in mind in particular, in forum nonconvenience cases, there's a Supreme Court case called Sinochem, which is cited by every defendant that wants to get a case dismissed to China. In that, I won't go into the details, but in that case, we have a district court decision, which did dismiss to China. And that was appealed, but on the grounds that had nothing to do with the dispute over whether China was an adequate forum. It was a
but what was the actual holding?
Issue.
What's the actual misstated holding there? That China's legal system is fair, or that you're not supposed to inquire about it?
No, the holding of the Supreme Court was on a completely different technical issue. If you want to know, the holding of the Supreme Court was on the issue of whether the court had to determine that it had personal jurisdiction over the defendant before it decided to dismiss on FNC grounds or after.
What's the
They heard not a single word of evidence.
What's the misapprehended?
Pardon me?
What's the misapprehended holding?
So the misapprehension is to say that the Supreme Court ruled or found or held that China constituted a fair and an adequate forum.
You're not supposed. Anyway, okay, that answers my question.
Right. Which they did not do. They didn't hear any argument about that.
Right. Okay. Interesting.
I'm sorry for that.
No. I want to just get that. It's a in my view, you can't have a factual precedent. That doesn't make any sense. The facts change. Anyway.
Yes. The district court found that China was an adequate forum.
Right.
But nobody above the district court found that, because that wasn't the defendant's, that wasn't the dispute that went on appeal.
I've read many bad district court opinions in my time, so I totally believe that that's the district court holding. Quickly, Professor Zambrano, toward the end of your written testimony, you lay out some smaller steps courts can take under current law in the absence of an anti-SLAPP statute. And I think you give a pretty persuasive case for a federal anti-SLAPP statute. But I notice you don't mention, or maybe I'm misreading it. I noticed you drop a footnote here to my old classmate, Maggie Gardner. That's great. Great job, Maggie, if you're listening. Sorry. You don't mention Rule 11 sanctions, which my understanding is judges, even on their own motion, can impose. Is that an option here? Are there downsides to that? Should this be used more? Essentially, Rule 11 sanctions for frivolous lawsuits.
Yeah, I think it is an option, but courts have refused to apply them in these cases. So one of the parties, and I may be misremembering, but maybe the Turkey case, they filed for Rule 11 sanctions and the court did not grant them. Generally speaking, I've argued that there is a norm in the federal judiciary against sanctions. And so Rule 11 gives the court the power to sanction attorneys for filing, in other words, harassment lawsuits, frivolous claims. But judges are very reluctant to do that. There's a norm in the federal judiciary and among lawyers that this isn't the kind of thing that you do in the federal courts. You don't move for sanctions because you don't want to chill zealous advocacy. Okay? And that norm, I've argued in other research, comes out of the 1990s, of a reform effort of the language of Rule 11. And because of that, I think judges are not only, reluctant to grant Rule 11 sanctions, but when you add on top of that a foreign sovereign, even more reluctant because of this problem that we've been talking about today, that judges are wary of disturbing the executive's and Congress's foreign affairs powers. And so they walk very carefully whenever a foreign sovereign is involved. And for that reason, unless we had a complete norm change in the federal judiciary, Rule 11 sanctions are not the right tool at the moment.
And you said that norm came about in the 90s with a revision of the FRCP, which came about from a committee of judges, right? Actually, I don't know how the FRCP.
Yeah, the advisory committee, the Civil Rules Advisory Committee, appointed by the Chief Justice.
Right.
They're generally in charge of offering reforms to the Federal Rules of Civil Procedure. And in the 1980s, there was a reform that made the rule much harsher. And then the advisory committee backed off in the early 90s and returned to a less harsh language. And in that debate, it was quite common for judges to express kind of dissatisfaction with a harsh rule. They felt uncomfortable.
Is there any reconvening, reconsideration of the rules on the horizon?
Not on Rule 11, as far as I'm aware. I don't think there have been any attempts to reform Rule 11 in the past 20 years.
Mm-hmm. If that's the way you change the norm, maybe it's something the Chief Justice should think about. Anyway.
Thank you.
Well, let me jump in on that, because that's a fascinating exchange there, and I think it also speaks to the scale of harm that you described earlier in your testimony. Our system does have in place rules and procedures for sanctioning frivolous filings by attorneys and dismissing lawsuits that cannot articulate a claim for relief. But that would not remedy the harm that your proposed legislation seeks to remedy, which is the harassment, the expense, the chilling effect, correct?
That's right. I mean, if you look at the Venezuelan claim against the Wall Street Journal, it was extremely frivolous. There was no chance that that lawsuit would succeed on a defamation claim. And the Venezuelan plaintiff continued an appeal to the Second Circuit after it was dismissed, because again, all they want is to impose costs. So even if they're sanctioned and just have to pay a little bit of money, these are deep-pocketed plaintiffs, so they don't mind that.
Well, switching gears for a kind of a broader question, we've been exploring here today and throughout the entire hearing on how our system and our courts engage with, apply, and interpret illiberal laws from authoritarian regimes like China, and legal actions brought by authoritarian entities, and what deference or recognition to lawsuits should be afforded to judgments rendered in those jurisdictions, or to representations by those countries and those regimes as to what their law is and the adequacy of their system. And that is difficult enough as it is for our courts to navigate. I want to ask a question where the asymmetrical nature of this conflict between the two systems is brought to bear in somewhat of a more indirect manner, using the example of the Huawei executive who the U.S. sought to extradite to face trial here in the U.S. on fraud charges. She was detained in Canada, took full advantage of the protections afforded to her under that process, which would be a relatively routine process for determining whether the request was valid under the extradition treaty between the U.S. and Canada. Had counsel, which is her right, and if extradition would have been granted, it simply would have sent her to the United States to face trial, where she would have been afforded all the protections, procedural safeguards that any criminal defendant has. 2 days, or I shouldn't say that, soon after the extradition request came in, 2 Canadian nationals are detained in China on very unclear grounds and held for years without charges being announced. And to make a long story short, used to pressure the Canadian government and the U.S. government to drop that request and drop the extradition proceeding. And the Chinese Communist Party is able to leverage and pressure Western democracies and judicial systems like ours because of their ability to rule by law, to influence their judicial proceedings without constraint. And a very thorny issue for us to navigate, where China uses its party-controlled judicial system in a manner that had an impact on our independent judiciary. So what do we do? Yeah, I'll open it to the panel.
I do think that you are totally right to point out that there's a complete lack of reciprocity here. Often a lot of these doctrines in U.S. courts are based on the idea, not just on international comity, that we should give respect and deference to foreign sovereigns, but also reciprocity, that we treat other countries with respect and dignity because they will treat us with respect and dignity. Well, it turns out that they don't. I mean, just looking at access to court, right? We give foreign countries, as I mentioned earlier, limitless access to court. We impose no barriers on it. But these countries don't give us the same access to their courts, and they certainly don't give our citizens that same access to our courts. There was an idea floated in the 1800s that access to courts should be reciprocal, that U.S. courts would refuse to give access to a national of a country that didn't give equal access to American plaintiffs. But that idea was dismissed, but was rejected by the Supreme Court. And part of the concern is that, well, we would be punishing nationals for what their foreign governments do, and that's not fair either.
It would be confronting their illiberal system by becoming more like them.
Right.
Do we want to do that?
Exactly. Right. And we benefit from a lot of these claims in U.S. court because they're disciplining our companies, right? So if there's a famous 1960s case involving the Cuban dictatorship where Fidel Castro's government sued an American sugar company to collect on a sugar shipment. And the Supreme Court had to deal with this problem of, do we give them access to court or not? But if it is a legitimate claim, it's disciplining an American company that's misbehaving. We want that. We want a better market here. We want our companies to not engage in crimes abroad either, right? We have the FCPA for that reason too. So you could make a lot of arguments for why we don't have to rely on reciprocity, but I do think more broadly Congress should, and I think it has considered what they call the True Reciprocity Act of 2020, I believe, was a bill of trying to ground the relationship with China on more reciprocal terms. I do think that makes sense.
Mr. Clark? Or Mr. Cohen, anything to add? No?
I'm sorry, were you asking for?
No, just if you had anything to add.
Oh, yeah. Well, so I guess true reciprocity would mean that the United States, or in this case, Canada, would be able to go grab a random Chinese citizen. Just depending, we can get Xi Jinping's daughter if she's at Harvard, something like that, and I think we probably all agree that's a non-starter. The difficulty in that particular case, I think, was just an inadequate reaction on the part of the international community, and to this, completely outrageous behavior of hostage taking, which is what it amounted to. And I don't think it's something that can be fixed within the U.S. judicial system. I don't think it's a flaw in the U.S. judicial system. It's a flaw on the part of the international community that they are unwilling to, that they are willing to kind of put up with this kind of behavior by China.
I just might add one observation. It's not exactly germane to your question about Meng Wanzhou and Huawei, but I think there's this temptation to look for something quick and dirty, so to speak, that we can impose reciprocal pressure for something unfairly imposed on our citizens. And that temptation, if we exercise it at all, has to be narrowly tailored. So we saw in the Protect American IP Act that was signed into law, I think, early January, where there's a measure in place if a foreign person steals U.S. trade secrets, where they would be subject to a range of U.S. export control type sanctions. There's no requirement that the person first have exhausted legal remedies in the U.S., China, or any any other jurisdiction. Nor is there any kind of requirement that it's narrowly tailored or that the decision is somehow adjudicated by a U.S. judge or even an administrative law judge, perhaps from the ITC. It just doesn't exist. It's simply, I guess, if the executive branch found that you did something bad, these are the consequences. Nor is there an effort to exploit, again, WTO remedies, which are very clear in Article 39, uniquely for trade secrets, that a member has an obligation to protect trade secrets, which seems to deal with these kind of economic espionage type cases. So this kind of overly broad tailoring, even if it's in the name of national security, is a WTO violation unless it's on the narrowest grounds possible. And in many cases, we're responding on this very broad ground that really threatens to undermine some of the other commitments that we would like to see in the global trading system.
Thank you. Well, gentlemen, thank you all for your time today and your excellent testimony. All the testimonies as well as a recording of the hearing is available on our website. I'd like to note that the Commission's next hearing will take place on Thursday, June 15th, focusing on Europe-China relations and transatlantic cooperation. We stand adjourned. Thank you.
A Russian man claiming to hold top-level secrets about Russian advanced bombers has just turned up at the U.S. southern border, seeking asylum. The man claims to have been an engineer at a production facility over in the city of Kazan, and he says that he possesses top-secret information about the White Swan Tu-160, which is the most advanced bomber in the Russian arsenal. U.S. border officials, they interviewed the man, and they determined that his story was in fact credible and eventually passed him off to the FBI, who are still in the process of interrogating him right now. However, analysts have pointed out that the fact that the story was even leaked to the public is an indication that perhaps the American government is encouraging other Russians who also hold top-level secrets to also escape to America. And if you thought that was interesting, well then you should click on that button below this video and check out Epic TV, one of the best no-censorship video platforms on the internet.